In view of preceding analysis, we do not find any merit in these read petitions. The same fail and are hereby dismissed. Signature, give, we'll do signature also so that they can see. Otherwise, they can read also.
Move lunch motion.
1 minute judgment. Let us pronounce the judgment first, then we. Oh. Give the other one in the meanwhile. Open. Yes, in view of the reasons assigned by the learned single judge in the impugned order and having regard to the findings recorded, this court is not inclined to interfere with the impugned order dated 22/6/2007 passed in WP 21839 of 2001 by the learned single judge. Accordingly, the writ appeal is dismissed. However, in view of submission made by Learned Advocate General and Learned Standing Counsel for the university that 85% of the competent authority quota seats alone had been reserved for local candidates for the state of Telangana in respect of institutions set up after formation of the state, that is 2/6/2014, and it is permissible for the students of other states including state of Andhra Pradesh to participate in 15% of competent authority quota seats. It is directed that aforesaid provision, if not already made, shall be made in the seat matrix notified by the university. In view of preceding analysis, we do not find any merit in these petitions, and the results say fail and are accordingly dismissed. September 11. Somewhere else 11.
My lord, sir, we are grateful.
Yes.
May I make a mention, Lordship?
Yes.
There is a can permission, my lord. My writ appeal of 2017, my lord. A writ appeal of 2017, my lord.
You want final hearing?
Final hearing, my lord.
Then move an application for urgent hearing. This repeatedly we are telling we don't grant mention memo for final hearing.
Subject to your lordship's kind permission.
1 minute. Yes.
My lord, with petition 20611 by 2023 was to be listed today, but
Today?
it is not listed, my lord.
Why? Give it to him. We will examine.
A contrary sensu, my lord.
Huh?
A contrary sensu, there are two other writs to be listed.
He will first examine. It is very serious matter that court gives a date and it is not listed.
Yes.
Please register judicial. You give it to. We will see to it. Yes, he will report it to me at 1:30. What has happened? Yes. Tomorrow. Yes.
Lordship,
Lordship,
contempt.
kind permission matter pertaining to
1 minute. One by one, madam. Please.
medical admission matter, my lord. My application should rejected. Though I am a local candidate, my lord, I am still taken as non-local. I filed my representation.
No. You tell Mr. This Singh Rao.
Yes, my lord.
Your
Please.
case. Yes. Supply a copy. Ensure that he is present. Right.
Yes, ma'am.
Yes.
Right.
One time registration, my lord.
One time.
One time registration, my lord, it was over, my lord. Now the third counseling is going on. She's a non-local candidate.
We'll see what is it. You want consideration? They should take no. What consideration? Not asking you. Consideration we are asking him, not asking you. You list lunch motion. Yes.
We have filed implete petition in,
Huh?
we have filed implete petition, my lord.
What is the urgency?
Urgency, because of the interim direction of this honorable court, the promotions were stalled since last 1 year. My lord.
1 year have been stayed.
My lord,
Promotions have been stayed.
stay. They are not taking up. The interim direction was only to
Day
consider.
after. Day after. Your implete petition will come up day after. Yes.
Yes. Thank you.
You give it, Mr. Give that to me.
Published DRT. Matter pertains to DRT.
DRT. Come. What is the order?
Actually,
Ready?
for the extension of interim.
No, ready. What is the order impugned in the petition? We are hearing right away.
Pay the
What is the order?
amount which has been allowed in the DRT. Pay the compensation amount of DRT
Compensation amount?
for the payment of orders option.
Compensation amount.
Not compensation.
You have violated somebody's right, so you have been held liable to pay compensation.
Sorry, my apologies. Not compensation. There was order passed in the DRT to pay the amount of 1 crore on or before 31 July lottery. But due to the petition
Under which provision the order has been passed?
under SITI Act,
SIRFACE Act.
under SITI Act,
Which provision?
13, under
13(4).
13,
What is the date of order?
31/7. 31
23.
Due to the petition, mother had been expired, he could not
No.
able to apply the
So
order.
what this thing? What's this thing? Satyavati Tandon says. All right, give Madam Satyavati Tandon in this petition. I get it listed today itself. What's your name? Granted, give the number. Order passed, apply, copy, get today. This petition, in this writ petition, comma, the petitioner has assailed the validity of the order dated 30C from the file verified. 31st of July 2023, passed by the passed by the debt recovery tribunal. Passed by the debt recovery tribunal in exercise of powers under section 13 of so and so act, SIRFACE Act. You know what is SIRFACE? We have heard learned counsel for the petitioner at length.
Just requesting for
Satyavati Tandon, and then in not inclined to entertain the writ petition. However, same is disposed of with the liberty to the petitioner to approach to file an appeal under section 17 of the debt recovery. Aforesaid liberty petition stand disposed. There can't be a better hearing than this, right? So expeditious. Yes.
My lord, this is 2016 matter adjourned on the 7th August. It was
No. 2016 matter. You want final hearing?
No, my lord, it was adjourned on the 7th August.
Why adjourned?
Adjourned means
Who adjourned?
your lordship only.
Why?
Because that UPSC has not filed the counter.
Then have they filed counter?
My lord, you have to file it 3 weeks from now.
Then no, you want it to be listed and again us to say that 3 weeks further time is granted to file counter. There is no urgency, Mr. Yes, next. If you want early hearing of the case, file an application for early hearing. We will deal with it. See, merely for this unproductive purpose for granting time, the matters won't be listed. Yes, next.
My lord is an IPS promotion. Already he has lost one promotion.
Whatever lost.
Another promotion is likely to lose. If
No. IPS means not bound by law. IPS means bound by the unproductive hearing, right?
Is the ACS.
No, what we are saying is, Mr. This is an unproductive hearing. Supposing if we granted lunch motion today, do you think we can allow the petition?
Sir, I'm asking for maybe posted next week or next
No. So what do you think? Next week we will allow and certified copy by evening at your residence.
My lord, if you
Let them first, Mr. Please let them file the counter. Then we will deal with it. You move when they file the counter. This unproductive hearing.
for years they have not filed the counter. I'm sorry, my lord. That is the thing in the last.
I will inform the concerned council.
If UPSC has to
I
file.
will inform the concerned council for UGC to file the counter. Yes.
We will consider, Mr. Nothing is happening. If you want early hearing, fill an application for early hearing, it will be dealt with. Don't do this thing.
Promotions. That is the
We do not. Yes.
I'm requesting for a lunch motion, my lord. Matter pertains to the medical admission matter, my lord. I'm challenging Rule 33B, my lord. Local candidate issue, my lord.
That we have already dealt with Rule 33.
Yes.
Give lunch motion.
Requesting for lunch motion, my lord. Same thing, my lord. Medical
Adjournment?
Lunch motion, my lord.
Ah.
Same matter, my lord.
Same matter, yes.
Non-local.
All right. Yes, yes.
Seeking lunch motion, lords, she got admission in the medical college, lords. In time, she is not reported in the college, lords.
Huh?
15 minutes waiting, lords.
You supply a copy to Mr. Rao and see that he is present. Yes. All right.
My lords, if I may seek leave to
One
mention a
minute.
matter.
Yes.
But the matter relates to illegal excavation of
Huh?
sand from the irrigation canals, your lordship.
Ah. Fresh matter, fresh.
It's an old matter. It's been listed since 1 year, your lordship. Now the
Ah.
urgency is that
You suddenly woken up to find out it's not listed for 1 year. It's a public interest litigation, right? So what is happening?
urgency is that, your lordship. There
No, first of all, you need to tell us, why do you want listing of the case?
the urgency is that the respondents, what they have deposited 7 crores as a security, in that they are withdrawing, your lordship. If the amount
You want that money, right? Public interest petitioner wants that money, some share in that 7 crore deposited.
for the irrigation department to recover the damages, what they have done, your lordship. That
Hey,
is,
why do you want the listing, Mr.?
the matter has to be decided, my lordship, because once.
Then file an application for a final hearing. This rule applies to public interest litigation also. You are not exempt. We are repeatedly, every day we have to tell that if you want final hearing, please file an application for fixing a date. Yes, madam.
Yes. Your Lordship, CC number 1250 of 23, date was given on 17th August, Lordship. It was supposed to be listed on 17th August.
Madam, this all, we don't know. You should understand the distinction that there is a distinction between court fixing a date and system fixing a date. Right?
Sure.
What is the urgency? You want them to go to jail, right? Huh?
No, Lordship.
Urgency, what is urgency?
Lordship, I have,
It may be a system given date.
Lordship.
So it must not be a court given date.
Given date, Lordship, interim order is.
So, madam, then 17th August, today is 11th August. After 1 month, you are remembering that 17th August not listed.
No, Lordship. Thing is that I was under impression that it will be listed. I have given a letter to the registrar judicial to list the matter.
Easier.
So far, it
So
is listed.
is it a given date? 17th
Yes,
August?
yes, Lordship. There is an order of 4th July,
Ah, yes, we will see to it.
Lordship. Another matter is that, Lordship,
One by one. Acha, all right. What is the other matter? That is also the court given 17th August not listed.
no, Lordship, that's a contempt case that is being.
All contempt. What is the urgency, madam, in contempt?
No, one submission, Lordship. I have filed an IA to recall the contempt case because that was disposed of in my absence. Some other counsel has filed wakalat. While I was there on wakalat, some other counsel has filed wakalat and got disposed of the contempt case.
The day after.
Obliged.
No, means you are saying that he had no authority.
No,
He must have filed wakalat, madam.
Lordship, my
Think about before recall and all that. And what we would request you as a young counsel, you should study the this thing, very good library you have, right?
yes, Lordship.
Recently it is inaugurated. Go there, make use of it, understand, go today in understanding the distinction between review and recall. What is the concept of recall? What is the concept of review?
No,
Day after tomorrow.
obliged, Lordship. Obliged.
But you must study, madam, today.
Okay.
You have filed an application for recall. Recall means court had no jurisdiction.
Obliged.
Please study. Yes.
Permit to move lunch motion on medical admissions for a teacher.
Ah, yes. How many? Two? Yes. Yes, please.
Medical admissions, Lordship, permitted to move lunch for.
How many cases? One? All.
This matter pertains to medical admission, my lords. I am permitted to move.
Yes.
Gate petition and the SITI proceedings with us.
Surface day after.
My lords, seek permission to mention a matter in the list, my lord.
No. We have stopped that practice. It will be called because see, we have been receiving complaints that people like you may be making a mention in respect of item number 95 and seek an adjournment. Obviously, you don't want to argue the case right away. You are seeking an adjournment and the other counsel may not be present.
In fact,
we
in
have
this,
stopped the
in
practice.
this matter, in fact, the lordships have ordered to file such documents.
We don't
Yeah.
understand. We don't know. It will be called whenever
Very
it is
well.
called. If you are present, fine. Otherwise, you can go home. It's our duty to do justice. We will, when the case is called, we will do it.
Very well. I will
Thank
get you.
Yes. 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 None for the will issue. None for the appellant.
Correct.
From perusal of the record. Yes, we are issuing notice, Mr. Harendra Prasad. We want to know whether they are similarly situated. No. So that's why we are issuing notice.
Suppress that fact.
None for the appellant record peruse. The appellants had, from the perusal of the record, it appears that the appellants had filed a writ petition, namely WP number 31161 bar 2016, seeking to declare the action of District Collector Ranga Reddy District and Special Grade Deputy Collector Chelvela Division in demolishing the compound walls, structures and watchman room, and in detaining the watchman in respect of land measuring 11.12 acres of survey number 83 bar 1 situate, say 83 bar 1 situate at village page 5 you will get para 2 Raidur Pan Matka Pan Makta MAKTA village Sirilingpalli Mandal Rangareddy district. Full stop. It is the case of the appellants that contrary to order of injunction passed in OS 455 bar 2011, the aforesaid construction of the appellants was demolished. Full stop. Paragraph learned single judge by a common order dated 28/4/2023 passed in WP number 31161 bar 2016 submitted that held that the petitioner stroke appellants have no title in respect of land in question. Paragraph. From against common order dated 28/4/2023 passed in WP number 30855 bar 2016, a writ appeal namely WA 697 bar 2023 was disposed of by a bench of this court by an order dated, what is the date of order? 24/8/2023. Full stop. It appears that the appellant claimed clarity in treatment. The aforesaid submission has been opposed by learned Mr. Harendra Prasad, learned counsel, for appearing on behalf of respondents 1 to 4, 5, 1 to 5 and 7, right?
1 to 5, 6, 7, 6 or 7.
Respondents want to then say issue notice, right? Issue notice on behalf of respondents is accepted by Mr. Harendra Prasad. You are ready, right? Today itself.
Trend is.
Can I seek a short passover? Sorry.
No passover. We are issuing notice. It will come up then. He is saying that your case is not covered with those of petition WP 30855.
I have an injunction against the appellant and.
No, then Mr. Injunction is writ is not the forum. If they are violating the injunction 39(2)(a), that we can do right away.
Injunction
Say that the order passed by the learned single judge will not prejudice you from prosecuting your remedy under 39(2)(a).
You're not sure, pass it over and dispose of the matter. Sorry to make a request.
You are standing here just to say that it should be passed over at the beginning of the.
Sorry.
Yes.
Not sure.
You think about it, 39(2)(a) you can prosecute, but this is, and Mr. This is all new trends. I mean, we are noticing here. Listen, new trends. The suit seek injunction. If it is violated by anybody, straightway go to the High Court and say that order of injunction has been violated. Punish them under 39(2)(a). This is the writ petition, right?
I have an injunction.
Mr. We have understood. You have an injunction and you want again an injunction from the writ court. And then again we will grant, you will again go to Honorable Supreme Court, again seek an injunction in SLP, injunct them. So 3 injunction, then you will migrate to International Court of Justice. You have a remedy, Mr. Answer this simple question, right? Next date of hearing if you are not ready.
One
Fine.
statement may make, my lord, appellants in 657, my lord, against them I have an injunction, my lord, my lords have disposed it of. Respect to 53 acres, my lord. In 53 acres,
Against you, no injunction has been passed. That is against the state.
Numerous.
In 650, whatever, 690.
697.
With the injunction is against Mr. Harinder Prasad.
I'm also seeking the same injunction, my lord.
That's what he's saying, you are not similarly situated. You argue, we are ready to hear.
I'm sorry.
But that's why we have issued notice that you are claiming parity, he is saying no. So please argue.
I seek a pass over on that. Sorry, my lord.
Write this record perused. In the when the order was being delete everything, notice, etc. When the order was being dictated, Mr.
And Kiran representing Mr. V.V. Nasir.
Mr. Kiran entered appearance in the case and placed for adjournment. List after 2 weeks. Yes.
Please accept my apology.
Yes, who appears?
Response 2 to 7, Your Honor.
No.
None.
Please appear. Password. It's yes.
That, Your Lordship's correct.
78.
86.
78.
May I please the Lordship's?
Yes. Heard on the question of admission, petition is admitted for hearing notice. No, what is 78? No, on notice.
28 notice for 1 and 2.
1 and 2, Mr. Praveen Kumar, DSGI,
Item 78, my lord. I
and issue notice to remaining respondents. No question of stay, Mr.
Should I kindly consider this honorable court was pleased to granted stay in a writ petition, my lord, where the very
You are challenging the validity of section 97 of the Organization Act.
as pursuant to consequent to thereof, the models was
Let them file this
my
thing.
submission. Lordship may kindly consider. I'll submit one thing and I'll leave it to Lordship discretion.
Yes.
The very same memo where the presidential order was not brought under the purview within 36 months prescribed by the Honorable President. The entire organization, the unit of appointments should be organized within 36 months. Beyond that, on 5/7/2022, they have sought by issuing a memo. The government has to pass GOMS number. They have issued a memo, want to organize the same thing. Preferences have been called for. This honorable court pleased to sustain the impugned proceedings. The very same proceedings, may I draw the Lordship's kind attention.
So it has been stayed, right? Another stay is not needed.
Despite of this stay, a meeting was conducted. That is
Contempt. Answer is contempt.
those individuals in the
Answer is not don't order of injunction granted by trial court, file a petition that saying that comply with order of injunction. That is not the case.
Lordship may kindly consider one submission and the page, Lordship may kindly come to page 124. Same order I am seeking. They are insisting, they want to implement only in respect of the petitioner who got stay. And remaining persons, once the stay has been granted on 5/7/2022 proceedings, it should be operated in the entire state. They cannot implement for the individual because they are implementing, they may not file the contempt, but they cannot recourse the action.
Council, we have granted some time for getting instructions. The challenge. We consider the prayer or grant after they file seek instructions. We are not rejecting it. Ex parte thing we are not. Since you have challenged the validity of the act, we have admitted it.
My interim,
How you want interim order without this thing? There is already a stay in your favor, right?
there is a stay
That doesn't mean that we should keep on granting stay.
in respect of the individuals who approached this honorable court. Some of the teachers have obtained the stay by this honorable court. And remaining teachers.
Say that they should continue here.
Pardon?
What stay has been granted in favor of individuals?
Page 121, that
You tell us.
the impugned proceedings 5/7/2017.
What is impugned proceeding?
Alignment was made in respect of the societies which were not organized under the purview of the presidential order. That proceedings was stayed.
All right, we are not inclined to grant that. Issue notice of IA 1 of 23 to respondents.
But may I make one?
Yes.
Lordship, so please observe the stage which was earlier granted will operate for this state. That is my humble submission. Otherwise, they will take a recourse of the implementation in respect of the teachers who were not obtained such an order. Lordship, so please my humble submission to that extent. Lordship may kindly observe to that extent. Already stay was granted in a particular writ petition that will be operate for entire state. That is my humble request.
File counters, my lord, in this matter.
You seek instructions. What is he saying? List on.
25/9/2023 for consideration of prayer for interim relief.
I'm deeply obliged.
Yes. See, Mr. Benefit cannot be made applicable to everybody. That's always a distinction. You study the position that it be made applicable to everybody sitting at home, sleeping. I'm
sorry, Lordship. I kindly consider, I may be allowed to make one submission.
25th September, we will hear you.
The memo was
Yes.
suspended in toto. That is my humble submission, not restricted to the petitioner therein.
Then be happy, file contempt. If action is being taken, file contempt.
I'm sorry for the trouble.
No. If you are thinking that there is already a stay, then file contempt.
Is third party, my lord, is not petitioner before this
Then
honorable.
how are you saying that it applies to me also?
Lordship, so please, if permitted me read the order, my lord, that will.
We will read it on 25th September.
I'm sorry, my lord,
No, not sorry. Why you have a right to argue? We will hear you on interim relief on 25th September.
because I'm troubling the Lordship.
No, not troubling. This is our job is to hear you.
I'm deeply obliged.
Let the necessary correction in the memo of appeal be made within 1 week. If corrections are made, office is directed to register. No, not this thing. Register this appeal which has been filed under section 37 of the Arbitration and Conciliation Act. Yes. None for the appellant, record perused. Petition is admitted for hearing. Appeal is admitted for hearing. Let steps be taken for service. Nobody is appearing. Let steps be taken for service of notice on
May it please, my lords. Lord, this is appeal against an order of the learned trial judge dismissing an application, my lord, under order 9, rule 30.
So you are served, right?
No, my lord, the learned judge.
Not served.
No, learned judge at page 22 holds. Summons have not been served. And my lord, two defendants.
No. This thing, proof of service has been filed on 7th of July 2017.
My lord, your lordship will see. Please see, my lord, the learned trial.
Your submission is not served. We will have to see the record then.
That is
Without record, we cannot decide.
true, my lord, but the learned judge himself holds. That, my lord.
So what's the problem if we say
Yes,
that the record is on
I agree. Record will reveal.
In order to decide, mark the presence in order to decide the issue whether the appellant was served with the summons of the proceeding, we have to peruse the record of the commercial court. Office is directed to secure the record of the commercial court. Let line below, let the appeal be listed immediately after receipt of the record of the commercial court. Yes.
I'm deeply obliged.
May I please your lordship? My lord, the grievance of the petitioner is that, my lord, petitioner is working in clear existing vacancy, my lord, on deputation in government of Telangana.
Word on the question of admission of
My lord,
petition is, you don't want admission, right?
yes, my lord, one sub. Lordship, my lord, one
You
sub.
don't want admission of the petition.
There is an urgent.
You then, what is? You want its dismissal, right?
No.
We were admitting it, you are saying no. That means the another inference is that you want dismissal of the petition.
I'm sorry.
Therefore, you are arguing, yes.
I'm sorry. My lord.
Yes. We are admitting the writ petition.
Very well. There is an urgency. May I make a submission, my lord. She is relieving orders are issued, my lord. She has to go and join in government of Andhra Pradesh.
She can go. It's not some other country.
My lord, it is covered matter, my lord, by this honorable court, my lord, where it was.
Which covered matter? Where?
Yes, my lord. My lord, page number 52, my lord.
52. No, there is no. Which, Mr. 52 is nothing. Some pages.
52 of my petition, my lord.
Huh? You see 52 is like this order. Paragraph 33,
Para
34.
33 relevant portion, my lord.
So what is the covered matter? Which order passed in WP?
Yes.
Or para 53 is 33 is covered?
Lordship, writ petition number 21300 of 2020, my lord, where the subject.
No, have you filed 23775 order passed in 23700?
My lord, page number 52 is the relevant portion, my lord. Page number 52, relevant para is para 33, my lord.
Mr. Please appreciate the order begins at page 43, not 52.
Yes, please. I wanted to bring to your lordship's relevant para. I didn't want to trouble your lordship.
So you should first say that this is covered by an order passed by division bench of this court on so and such date.
Sorry.
So you are reading para 50. This order was passed on 27/4/2023 and a half years ago.
Yes, please.
What were you doing?
My lord, similar subject matter was considered, my lord, where.
Your name is similar is what? Senior assistant in Office of Commissioner of Survey Lands, Andhra Pradesh, Vijayawada.
My grievance is that, my lord, I am working on deputation in government of Telangana. I was allotted to government of Andhra Pradesh, my lord. Where, my lord, after bifurcation of erstwhile government of Andhra Pradesh, there was no provision for interstate transfer between the state government employee and central government employee. But there was provision for interstate transfer between the state government employees, my lord. Therefore, this honorable court adjudicated the matter, and even though in the absence of such provisions, where the spouse is working, if the spouse, one of the spouse is a central government employee, then the state government employee can be placed in that particular position.
She's already working, no? Please see para 6. You said that you've been continued in state of Telangana.
No,
as on today.
She is relieved, my lord. That is the relieving order of challenge, my lord. 8/8/2023 is the relieving order, my lord.
You have to hear the other side.
Yeah, but my grievance is that, my lord, interim of stay may be granted, my lord, because she is relieved now. She has to go and join in government of Andhra Pradesh. She has two children, my lord, where one is in 4th standard, another is in 10th standard, my lord. Therefore, now since it is a covered matter, my lord, lordship may grant interim stay until the disposal of the writ petition, my lord.
You decide it's a covered matter, right? And you decide to grant an interim order. You grant an interim order, sit on to him signing interim order. Then why us? If you are telling us that it's covered, interim stay has to be granted, then why we should hear this case? No, we will adjourn this. You pass an order covered and sign it and give it to him. He will comply.
I'm sorry, my lord. That is not my mission.
No, you are saying it's a covered matter, therefore stay has to be granted.
I am making a humble request, my lord. Lordship may see the relevant portion. I'll satisfy your lordship, my lord.
Ask him.
See, in this order, what you referred, they have to ascertain whether any vacancy is there.
It is there
in this point of time.
Hey, you say vacancy is there, you say covered, you say stay is granted, then why have you implemented them? Delete them. Nobody. File a petition, say vacancy is there, similar matter, stay has to be granted, then we will not even issue notice to anybody. They are not to be heard according to you.
I'm sorry, my lord. District collector has addressed a letter, my lord, where their clear vacancies were indicated, my lord. There are 8 existing vacancies and there is a necessity of the employees, my lord. That is my submission.
We covered granted. You say it's granted, then why have you implemented them? Delete them. Nobody. File a petition, say vacancy is there, similar matter, stay has to be granted, then we will not even issue notice to anybody. They are not to be heard according to you.
I'm sorry, my lord. District collector has addressed a letter, my lord, where their clear vacancies were indicated, my lord. There are 8 existing vacancies and there is a necessity of the employees, my lord. That is my submission.
You say it's granted, then why have you completed, then delete them. Nobody sign a petition. Even the vacancy is there, similar matter, and stay has to be granted, then we will not even issue notice to anybody. They are not to be heard according to you.
I'm sorry, my lord, district collector has addressed a letter, my lord, where clear vacancies were. There are 8 existing vacancies and there is a necessity of the employees.
That is covered. You say it's granted, why have you completed, then delete them. Nobody sign a petition. Even the vacancy is there, similar matter, and stay has to be granted, then we will not even issue notice to anybody. They are not to be heard according to you.
I'm sorry, my lord, district collector has addressed a letter, my lord, where clear vacancies were. There are 8 existing vacancies and there is a necessity of the employees.
You say it's granted, why have you completed, then delete them. Nobody sign a petition.
The web counseling will close for third phase.
No, madam, why you did not file? We granted you time.
Yes, Millet. Saturday or second Saturday, Millet, Friday this order
No,
was.
then you can pass on at least the copy right away. We are,
Your Lordship may kindly pass over short Millet. I will get, I file Millet.
he has it, madam. Mr. Rao is pro-student approach, even though you don't bother. He bothers for them.
Millet, I have
And
filed
this not
Millet.
is concerned, therefore we have got it.
Yes.
Which rule you are entitled, madam? Now at least tell us.
125 and 126 Millet, they mentioned that.
Which rule, Mr. Rao?
Page 2, Millard, Roman 4, Lordship.
Page 2, Roman 4.
Roman 3, Roman 3.
All certificate.
Registered eligible candidates shall exercise web options from the first phase of counseling onwards. If the candidate does not exercise web option, the first phase of counseling, he or she shall not be eligible for the option. The petitioner did not exercise web option.
No, where are you reading?
Top.
All registered and, yes. So what happened to the petitioner, Mr. Rao, in this case?
Petitioner failed to exercise web option in the second phase of counseling.
Failed to
On the
exercise.
ground of real health, Milord. Now she wanted to exercise web options third phase of counseling. The rule is brought to, Milord, the amendment is brought to the rules only on the ground, Milord, it's to protect, Milord, the
finality into the proceeding and prevent seat blocking.
Yes,
yes, madam, what do you say?
Millet, the rules Millet, the same Millet, the first phase Millet, she has option, she has exercised her option. The rule specifies Millet first phase. Candidates who have not exercised the.
You have the rules, you don't have, madam.
Millet,
they have to challenge the rule, Milord. If they want, they have to challenge the rule.
Millet, I am not challenging the rule, Millet. I am only saying, Millet.
Fine.
Millet, I am only saying, Millet, that under the rules, the first phase of counseling.
No, this thing can be granted to you, madam.
Millet, I am only seeking, Millet, to consider my representation, Millet. She has opted, Millet, in the first phase.
Hey, do you want consideration of your representation?
Yes.
That we can grant?
Yes.
But not direction to permit you to exercise web option.
I am asking for consideration of my representation.
And that can be, Mr.
Millet, by tomorrow, Millet, the third phase will close, Millet. She tried to exercise her option. It was.
Why to then decide it on merit? We will decide it. Why to ask them to decide? You have come here, we ourselves will decide. So, madam, Mr. Rao, you will have to give her rules also so that it's your obligation. You have been pleaded first to supply copy of rules, tell them under which provision they are entitled, not entitled. The huge responsibility lies on your shoulders.
I already passed it on.
Please read, madam. Then at least you can do is to read it.
Millet, that is what, Millet. I had filed, Millet, today. The copy is there, Millet. It's filed in the.
No, he has given a copy to you.
Yes, Millet.
Then
Along with that, Millet, I am bringing to the notice, Millet, about the subsequent events also that she tried to exercise her options. On Saturday, Millet, the notification was given. Bringing those facts also, Millet, I had filed an IA along with all the notification and her screenshot, Millet, of her application being not permitted to be exercising the options. That is why, Millet, I filed the IA along with all the rules and the notifications, Millet.
We are hearing you, madam.
Yes.
Please argue.
Yes.
Hmm.
What I am stating is, Milord, that according to the rules, let all registered and eligible, and Your Lordship, page 2 of the GO, Your Lordship.
Yes.
So, after sub-rule 4, the following shall be added. All registered and eligible candidates shall exercise web options from the first phase of counseling onwards. If the candidate does not exercise web options in the first phase of counseling, she shall not be eligible for further phases of counseling. She has exercised her option in the first phase of counseling. Rule speaks of only the first phase of counseling. For candidates who have not exercised in the first phase of counseling. She has exercised, Milord, in the first phase of counseling. In the second phase, Milord, she had conjunctivitis, she could not exercise. I have explained the circumstances, Milord, as to why she could not exercise and made a representation seeking that I may be permitted to exercise my options in the third phase and subsequent phases, if any.
Yes,
My
Mr.
habitual lordship says, Milord.
See, the rule, first part says first phase of counseling onwards.
Onwards.
And then, but first phase of counseling, he shall not be eligible.
Your Lordship may kindly see, Milord.
So the contention is second half of the rule, second portion of the rule only prevents this.
Only those who are not exercised web option first phase of counseling.
That's the submission. So she has not she has exercised first phase and not exercised second phase due to conjunctivitis. Therefore, you should permit her to exercise. What do you say with regard?
My habitual lordship says, Milord, the rule is, the amendment is brought to the rules only to protect the seat blocking. But earlier, Milord, about 80 to 90.
Then why should you say that he does not exercise web option in any of the round of counseling? Why first round of counseling? So therefore, they say that even in third round also she cannot indicate the web option. And if any further round is counseling, she can file a petition saying that I have not exercised for second and third round of counseling, and now if any round I am entitled. This is the argument.
Further, my submission lordship says, Milord. The candidate, Milord, Lordship may kindly see, Milord, the reason for not exercising is conjunctivitis.
Conjunctivitis.
Milord, web option is not, just you have to click in a, Milord, cell phone. That's all. Click in a cell phone, giving options to the particular colleges. That's all. Competent authority portal. Milord, it is not a reason, Milord. Milord, if this is the last phase of counseling. Milord, a candidate takes, Milord, allotment letter, doesn't join. Then the seat goes to the private medical college to fill up its on its own. Without Milord, the merit. Meritorious candidates, Milord, will lose the seat.
Yes. Subsequent to answer. Yes, madam. No, this word, if we, according to you, I mean, this seems to be slightly, I mean, we are finding it difficult to accept that she has indicated in first round, therefore, second and third round, she can not, even if she doesn't indicate, she is entitled. This can't be this thing. Because see, if you read the manner you want us to read, the expression onwards will be rendered with use. Onward.
Yes.
All registered. The object is obviously to prevent blocking of seats.
Milord, this is a peculiar circumstance, Milord.
What is it? Only you have to mobile.
In the peculiar circumstances, Milord, it's not as if she wants to block the seats as things stand, Milord.
Madam, you consider, we can direct you to consider, but ask, because we are bound by rules, we have to interpret. It's not peculiar.
Yes.
10 persons will come saying that like you.
That-
We are all watching, standing outside. What happens to this petition?
true.
We can't do it. Yes, in this petition, the petitioner is an aspirant seeking admission to MBBS-BDS course. Full stop. The petitioner had appeared in the NEET UG examination and was declared successful. Full stop. The case of the petitioner is that even though she had indicated not even though she had indicated web options in the first phase of counseling, however, she was not allotted any seat. Paragraph. Thereafter, on account of conjunctivitis, the petitioner could not indicate web options for the second phase of counseling. Phase of counseling. Thereafter, the petitioner in this writ petition seeks the following relief. Para 10. Which case this was matter? This was 84. 83. No, this was 83, no? 84? 83.
I'm an 85, my lord, which is going with 84.
1 minute.
My
Item 83. Yes.
lordship, may I request my lordship? My lordship, may I request my lordship?
No.
Kindly grant 1 week time, my.
Who are you?
I am for the respondent, my lordship.
84. Yes, 84 for petitioner. Let us hear him.
Yes.
Yes.
This is 1 page.
No, not 1 page. You argue.
I'll argue, Your Lordship. I've just handed.
Last time you were opposing the
Yes.
prayer. It's a public interest litigation and you should be ready to pay exemplary costs. Yes, argue.
My synopsis I'm handing over. Synopsis I'm handing over. I'll argue.
Last date you were opposing the prayer, right? Made by the other this thing. We had to record. Please argue. Yes. What is the urgency beyond our this thing? Comprehension. Award has already been passed.
This.
Do you understand?
I understand.
Then you have not challenged the award. That's the end of the matter. On the short ground, it should be dismissed.
The whole process is void ab initio. It is in violation of Article 254(2) because the endowments have.
Master, even a void order is required to be challenged. And you have to say that temple is so poor that and its trustees are so illiterate that they are dependent on you for prosecuting the public interest litigation. You will have to say so. In the writ petition, where have you said that the trustees of temple are so poor and so illiterate that they are unable to approach on this court on account of their poverty, and therefore entire this thing is on your shoulders? Which paragraph of the petition have you said so?
I am saying there.
No, please answer the question. That is the test of public interest litigation held by Supreme Court in Balwant Singh Chaufal and which has been reiterated several times. From bonded laborers case, when Swami Agnivesh wrote a letter that in Haryana bonded laborers are there and therefore the letter was treated as public interest litigation. So it is always public interest litigation is for such disadvantaged section of the poor who are unable to approach the court on account of their illiteracy or poverty. That's why the rule of locus has been relaxed. Not to this thing. Not a person like you who wants to fight the battle against this thing and you have an vested interest in it. We don't know. You may have. Why is the temple so poor? What are the educational qualifications of the trustees of temple? Give us. Who are the temple trustees and what are their qualifications? See Sita Ramachandra Swami Devsthanam. Who are the trustees?
I don't have that information.
Give the
and
particulars.
instructions.
This is a public interest litigation. You are assisting the court.
Yes, your lordship.
So therefore file it. How much time? With their qualifications.
Maybe the government is more appropriate to file this.
This is not then. This is not that you will file a public interest litigation. Government will find out what is happening.
My contention in this
Nothing
matter
but contention.
the endowments.
If you don't want to answer, we will pass an order.
I'll file your lordship. I'll file the trustees. I don't have.
How much time?
4 weeks.
4 weeks. In this public interest litigation, the petitioner inter alia has prayed for the you want to argue 85?
I just want your lordship's attention.
No, it will come along with 84.
My lord, I'll be at a disadvantage because unfortunately the manner in which
Give 85.
present here.
You want to, we will hear you.
Very good.
What's the problem? Yes.
Very good.
You are the petitioner, right?
I'm sorry, my lord.
You are the petitioner in this case.
Yes, I am for the petitioner.
You are, this is a public interest litigation seeking same belief.
Why so? Now, but what I am saying here is, my lord, squarely covered by the Supreme Court judgment directly, in all respects. That is why I'm just urging your lordship to.
No. We have two questions we are putting it to you. Same questions and anticipate that we think that you have heard those two questions.
I have heard.
1 minute.
Before the next day, perhaps.
Two questions. Please answer two questions. Number one is that awards in these cases have already been passed in under 2013 Act, which is not under challenge.
1
minute. Please, Mr. You will have to understand the question before answering, right?
Yes. So
first question is, awards have already been passed, which is evident from the counter filed on behalf of respondent number 3, 5, 6 and 6. Then second is that we want to know the particulars of the trustees of the trust. Are they so poor, so illiterate, they are unable to approach this court and the burden is on you to file this public interest litigation? Are they in the status of this thing, bonded labor, something like that?
Quite so much.
They can't defend because it appears but the award has been passed with their consent.
But Lord, kindly see, Lord.
On the basis of negotiations between the trust and the authorities initiating the proceeding under 2013 Act. The petitions we have already adjourned. If you want an adjudication, we will decide, to decide it for itself. Right.
Crucial dates are the only 2 dates, my Lord. Kindly, please.
So, Mr. You are arguing the case, right?
Kindly appreciate this.
This is for admission.
Yes, quite simple.
Admission. Yes. What is this? Why it should be admitted?
The relevant dates are, my Lord, kindly see. 1/3/2021 is the date on which the acquisition is supposed to have been taken. But on 2021, almost 6-7 months later, the endowments department itself admits very clearly it's a simple land. None of these people have, whoever they are trying to say the acquisition has been done, they were not even a party there. In fact, kindly see this page 83. Kindly have a look at page 83. Ma'am.
So you are arguing on admission, right?
Yes, ma'am.
Petition is admitted for hearing. Yes. Next.
This is a matter concerning appointment of chairman to human rights.
Yes, Mr. Prasad.
I have received a communication, lot of the details of the application received. But I'm requesting some time in the matter.
How much time? Last time you said process initiated, and you will tell us within how much time it will be.
4 weeks, Lord, because it is circulated to the highest authority.
So it will be positively be done.
I'm instructed to seek time 4 weeks.
Mr. Harinder Prasad Narend, senior, whatever, attached to so and so, submits that the praise for and is granted 3 weeks further time to enable him to apprise this court with regard to
Kanti Kumar Reddy counsel will respond.
Wait, please, Your Lordship.
It's
Not
not,
I have for the petitioner.
it's not well. His request of tomorrow, my lord.
Huh?
Counsel will respond. Kanti Kumar is not well. His request of tomorrow, lordship.
That is a case, blood, where blood are absenting blood during the blood COVID period. Blood the services of a court manager has
No,
been
no.
blood removed.
This is for IA 1 of 23.
Yes.
What is IA 1 of 23?
IA blood
Does not, can be granted. It's only for this IA. Not the presence.
it may not take much time if your lordship so pleases blood.
No, no, this is for interlocutory. This
That's true, that's true, blood. At the same time, blood, I am requesting your lordship that I may take 5 minutes, blood, your lordships to that.
Please file an application. Please file an application for urgent hearing. We will consider the petition has been admitted for hearing. It has come up on IA 1 of 23. We are passing in order. Please, you are one of
One submission that your lordship may kindly see. Rule 35, blood, rule 32, blood provides blood the procedure for filing an appeal. Blood. He filed an appeal against the dismissal order passed by the first respondent. Blood, that order has the appeal has been rejected on one line order stating that there is no provision in the appeal. Blood CCA rules would apply. They proceeded with inquiry under CCA rules. That they conducted inquiry under CCA rules. That appeal not lies. That when I filed an appeal, not I put not for the first respondent. Not
you are saying it should be remitted to the authority to decide your appeal on that.
at least not so that as an interim measure, your lordship.
Yes, not interim measure,
But
final measure.
and your lordship.
We are bound by law. We cannot do
My
whatever.
only thing is not for
I don't know. Your submission I have understood. We have understood that give an interim measure. Then supposing if appeal is decided, I will amend the petition, challenge the appellate order. He will stay here in the High Court. This is what you want. Yes.
Kanti Kumar,
This is this thing, right? Where is the order? There is a provision of appeal or not, Mr.
Blood, your lordship may kindly see blood rule 33 blood of Telangana,
Which page is the order as by the appellate authority?
yes, I will.
Page.
Page number, 115,
100
copy of the order 150.
One page. No. Acha, because there is no provision for appeal. Mr. What do you say?
Victory is not well requested tomorrow. The request is not well today. Request tomorrow, Kant Kumar Reddy. Victory Kant Kumar Reddy. I'm not aware of the facts.
Under which provision, according to you, Mr. Appeal lies?
33, your lordship may kindly see.
33 of classification control appeal.
Yes, exactly.
Learned counsel for the 1 minute. 1 minute, please appreciate. Twice he has told in your presence that the counsel is unwell. You can't be unreasonable to such an extent. That we are adjourning it to day after tomorrow. We are recording your submission.
Ask me to read the.
We are recording your submission that there is under 33 of CCA rules. Appeal lies. Learned counsel for the petitioner submits that the order, impugned order dated 3/11/2022 passed by the appellate authority cannot be sustained as an appeal, as appeal lies under Rule 33 of Telangana classification control and appeal rules.
Civil servants appeal.
Civil services classification, so
And
also
appeal rules.
CCA rules 2000. What is
16.
1960?
19.
Rules 2016-16 apply to the case of the petitioner. However, Mr. So and so prays for adjournment on the ground that yes.
Page 12 of IARs.
Well,
It's directed for making a fresh representation to the competent authority.
yes.
12
But the Dishonorable Court please to dispose of the writ petition, directing the university to consider its representation.
6-9 has it already been disposed of. Why it has come?
That is the direction to university. I want direction to the competent authority, page 12 of your orders.
Who is competent authority?
Mandal Revenue Office, Tahsildar. When my case is listed, Millard, it was tagged to item 3. My case was item 10.
He said, he told us that it's covered.
That is only, I filed already copy of your orders as page 12. In the main writ itself, that is covered under your orders.
Page 12?
Of IA, Millard, that I also filed in the writ petition also.
Which is page 12 of IA, madam? This is we.
In the writ petition, page 26.
Yes, Mr. Rao, what do you say?
The petitioner has studied 4 consecutive academic years in Andhra Pradesh. He was treated as a local candidate of Andhra Pradesh, not Telangana. Questioning that, it's quite a petition directing for seeking.
They will. Okay.
That's why kindly see me, Lord.
Now they will succeed in getting residence certificate from Tahsildar. That's why.
Resident, my father, everything. I got a permanent house and residence and everything.
But that is not the criteria. Lord. Residence is not the criteria. Please 16, Lord.
Where is the rate petition in WP 24312 so that we can find out that, like you also petitioner in that case studied in Andhra for 4 years, and despite that we have issued this order.
31st August.
No. This WP 24312. File a copy of this petition if you are claiming similarity.
Writ affidavit, Your Lord.
Read petition. We don't know what is your case is that from 9th to 10th to 9th, 8th.
9, 10, 11, 12.
8 to 12 you have studied in Andhra. You are a local candidate in Andhra. And thereafter you are coming to Telangana and claiming here also a candidate cannot be local in Andhra as well as Telangana. So you are relying on this order, WP 24312. right? Where is the copy of the petition to show that petitioner in that case also had studied in Andhra like you?
But your lordships already considered a batch of cases where the people studied outside of the state also, when they are permanent residents for 4 consecutive years, your lordships directly. Following that only this order has. I am a permanent resident of state of Telangana. My father is an employee. It is only for the purpose of study.
Mr. Rao, we will recall this order and we'll hear him afresh on merits. Perhaps other case will apply in his case because he is claiming the benefit of order passed by earlier occasion. So we have another order ready for him on the ground of delay and latches. When were you declared as local candidate? Non-local candidate? And when have you filed this petition? What is the prayer in this petition? Was in this petition, Mr. Mandamus. Mr. How you are saying that review and this thing? There is no prayer made by you. What read the prayer petition? Aforesaid facts and circumstances of the case. Order is to treat you as local candidate. And you have not challenged the validity of the rule. And we have in that order already held that the candidates do not fall under the rules. And we have read down, therefore benefit has been here. There is no challenge. So it got dismissed. Yes. Huh? What withdraw?
Review petition.
Withdraw. After arguing the matter to some extent, learned counsel. Password? Yes. None for petitioner even when matter is called in second. None for the appellant even when matter is called in second round. It appears that the appellant is not interested in prosecuting the appeal. The same is therefore dismissed for want of prosecution. Yes.
My lord, I'm begging your lordship, my lord, just your lordship may please to grant me 1 week time, my lord. I have to file some synopsis in this matter.
Nothing, no.
This litigation has commenced from 1342, firstly, my lord. Different stages matter lands have been notified as constituting the reserve forest to the extent of 2,000 acres. My lord, this later, my lord, your lordships are well aware the judgments in the T and Godavarman Tirumala case, and they later on some judges, series of judgments are there. My lord, these are all facts. I have to just to make a synopsis. Just
this Saturday, Sunday, what did you do?
Oh, my lord, these officers, I wanted the officers to come, my lord.
The officers won't prepare the synopsis for you, right?
I prepare, my lord, they will have to assist me in some a matter of this nature, my lord. It involving 2,000 acres more, my lord. My lord, 1349, that is equivalent to 1939. These lands have been come.
No, Mr. You should be happy. Nobody is appearing to oppose you. You'd like this thing.
I wish to have effective adjudication on this matter, my lord.
No, Mr. Don't think that we don't effectively adjudicate.
I should be a position assisting.
Don't say that we don't effectively assist adjudicate the issue. But is your impression somewhere else?
I'm sorry, my lord. If I convey that impression, I'm confident.
This is what effective adjudication means. Do you mean to say that the cases we decide ineffective adjudication?
Never, my lord. I should have the assistance of the officer. But I'm conveying that impression, not that. I'm sorry, my lord. Court is not. It's not. I mean to convey, my lord. These officers must come.
If we are good to you, that doesn't mean that you should take liberties, right?
Never I take.
No,
I never agree that liberty and attitude, my lord. It's my prayer.
You are saying effective adjudication as if not effectively adjudicating. We will show just now how effective adjudication is. How effective adjudication of the court is just now.
That I'm
We
perfectly
have
aware.
taken oath to don't do, mister. You stand up. We have taken oath to do justice. We will do justice.
Not that.
Go there.
My lord,
If it is against you, we
my
don't.
lord, I need some actual position, my lord, from the officers concerned, my lord. This matter, my lord, your lordship may kindly.
Mister,
This law.
Advocate General has assured this court that they will not seek any adjournment. You see, mister, you are sufficiently senior person. You are designated as senior counsel. You should listen to us. You should understand the impact of seeking an adjournment being a senior advocate of this court. So supposing we adjourn your case, every other case, if he stands up, no justification for telling him not to argue the case. He will say that to him adjournment has been granted, to me adjournment has been this thing. You will never understand the predicament of the judge. This is the problem. If we decide to grant adjournment, everybody, all these young people are sitting behind and watching us. They will also stand up and say that it be adjourned. What moral authority do we have to tell them? No, 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 you argue. And giving adjournment to you. And according to you, it is non-effective this thing adjudication of the matter.
That's true, my lord. It should not become a wrong. My lord,
Then argue.
may I invite your lordship's kind attention to page number 31. Order under charge before your lordship is this, my lord. Your lordship may kindly see the order. How cryptic this order, my lord. Despite more than 15 grounds I raised before the learned single judge. This is the order. This repetition is 5. Against order dated 7/4/1992, passed by the first respondent, confirming the order dated 9/12/1988, passed by the second respondent. The second respondent, by order dated 9/12/1998, after due inquiry, held that the claims of the petitioner before him, respondent herein since deceased by the legal representatives, are admitted under section 10(1) of the AP Forest Act 1967. My lord, this is a cryptic order, my lord. Leonard Single and pleased to pass an order. So, my lord, my argument before the Leonard Single judge is in 1349, these lands to the extent of 2,000 acres have been constituted as a reserve forest. As land, but firstly 1349, that is equivalent is 1939. These lands have been notified as a reserve forest and vested with the forest department. My lord, at 2 stages, this vesting of these rights in favor of the forest department had been upheld. In 1979, all of a sudden a letter was made to the forest settlement officer. Forest settlement officer declares that this is a private land. That suffers from the adjudicator. That's the ground I raised, my lord. Your lordship may please to see this. Grounds I raised before the.
You are not telling us the facts of the case, which is the order which has been upheld, what is it, how writ petition was filed, nothing.
My lord, this file could not be traced out, my lord. My lord, take it to my lord, I will.
No, we will read it. We have to pass an effective order, mister. Don't worry. We will pass an effective order without your assistance also.
Page number 13, my lord, this is the order of the forest settlement.
This you all. See, no, 37 is that one paragraph order. But what were the checks? Did you see this one? This you all. You have para 6. Your facts. Memo of appeal. So page 13. I don't have page 13. You have probably if you which page it's the order after the first appointment. Second. Then appeal over here. Appeal shall right to distribute and publicly decided in appeal. And this order will be in appeal. There is the order. Something. Until dividend. Does not reflect. Yeah. In that order. Yes. Somebody filed an application. First of all, our case of it, because done to see what who filed an application for the legal period. They don't file an application, right? Which are somewhere is there. Father of responding belongs. Yes, madam. And this intra-court appeal for adjournment. So yes, please. Yes, yes, please.
The appeal filed by the government lordship, Tribal Welfare Department.
Tribal welfare. Yes, what is it, Mr.?
My request lordship, which is at page number 26. The appeal filed by the appeal filed is not there. Government.
Certified. Madam, Andhra Pradesh Scheduled Area Land Transfer Regulation 1959. This 2G. 2G is contract of sale is also transference, which is not disputed. Madam, 2G of Andhra Pradesh, this thing, Scheduled Areas Land Transfer Regulation. So there is nothing, Mr. Correct view.
May I request, Lord? The learned single judge allowed on the sole ground, the agreement of sale, it is also valid transaction. On this ground, it was allowed. My respectful submission is, Lordship, the agreement of sale which is invalid, it is not in terms of the Registration Act, not in with the.
That is why full bench decision, no mistake. Invalid or not, it is for the purposes of that registration and that thing. Not under this forum, it can be examined. We will say that it is not registered, therefore invalid. But it comes under section 2G of Andhra Pradesh transfer regulation, correct?
Lordship, the.
You have to be fair, mister. We
Yes.
are not, you are an officer of the court. You have to be fair. Don't argue contrary to full bench. Nobody can.
Lordship, my
Yeah.
respectful submission is that.
Your submission is we will say that for 1 hour and 30 minutes counsel respectfully submitted and argued that order is illegal. But this is correct view, right?
The
Record at least you can say or not say. You won't say, never say. Fine.
Lordship, the
So-
judgment has no application, full bench judgment has no application in respect of the facts of the case.
No application, right. What else? Second submission.
Yes, Lordship, the Lordship.
Second submission.
The agreement dated is Lordship 6/1/1960
Ah,
prior to this regulation.
ah.
But the registered
Hey,
date
madam, this is 1969. Something else you are showing. Andhra Pradesh Scheduled Areas Land Transfer Regulation 59.
Yes, Lord.
This is 69.
In the same book, page number 148. Lord.
Ah, yes.
The same book, Lord, 148.
148. Ah, yes, correct.
Yes. The transfer, Lordship.
Transfer. Means mortgage with or without possession, lease, sale, gift.
Exchange or any other dealing with immovable property not being a testamentary disposition and includes a charge on such.
Or a contract relating to such property.
Yes, Lord. In respect of such mortgage,
Fine,
lease,
fine.
sale, gift, exchange or other dealing.
Includes contract.
My respectful submission is, Lordship.
Full bench doesn't apply.
Yes, Lordship.
What else?
Next, Lordship,
Why it does not apply?
The judge.
Just saying that it does not apply, but why it does not apply?
Yes, Lordship. Right. In these facts of the case, agreement of sale dated 6/1/1960, Lordship. Subsequently, it was registered 23/3/1964. After came into this regulation, Lordship. Therefore, it has no application. The registration took place after this regulation, Lordship. Therefore, it is an act of 170.
When the registration took place?
Yes, Lord. The learned.
No, registration took place when?
This 23/3/1964, Lordship.
And this thing,
Lordship.
23/3/64 registration took place. And
Yes, Lord.
when the rules came, regulations,
Yes, Lord.
permitting complete
Yes.
transfer.
The regulation 2 of with effect from 1/12/1963, Lordship. 1/12/1963.
All right. So it was not registered, therefore it is not a transfer.
Yes, Lordship. That's a one more ground, Lordship. The sale or the Lordships of it's only a agreement of sale. It's only shield, not a sword. In terms of the 53A also, Lordship, under the TP Act.
No, mister. This is all governed by this thing, transfer regulation 1959.
One more, Lordship, the transfer.
What does transfer mean in that
Yes, Lord,
regulation?
section 54 of the TP Act, Lord.
Just like that this agreement does not exist. Yes.
Lordship, section 54 of the TP Act, sale defined. Sale is a transfer of ownership in exchange.
No, we are not defining sale here. That Parliament has done section 54.
Yes, sir. But the law, it requires Lordship, section 2G also. The sale is absolutely not a transfer. It is based on agreement of sale. Therefore, there is a no ownership transfer from transfer to transfer. That is my respective submission.
You should challenge 2G then and say amend rule 2G to exclude contract relating to property in respect of mortgage, lease, sale. Yeah, Mr. You have to be fair. Can't argue contrary to statutory provision. It includes 2G includes, and he has taken permission from you. It's not that it's a forced document. Nothing. Thank you. Yes, that's it. Yeah. That's what he must have read, and he's arguing the same again. Same argument which have been, brother says, same argument you made before learned single judge, it was not accepted. Again, you are making the same argument reading there. Correct. Yes. Yes.
It is allowed on the right of agreement of sale, but it is a room for Lordship interpretation. It's a room for this judicial notice and draw the inference, which is not a
Judicial notice? What judicial? When can judicial notice be taken? Evidence Act. Tell us something. You said judicial notice. Where is the ground taken judicial notice?
The 2G which
What judicial notice?
Lordship, this is something cloud in the definition in the 2G.
Yes. Apply for a copy. Give an opinion that the High Court is wrong. Yes. What judicial notice? At least you should tell us.
My study.
No, what judicial notice? We didn't get it. What judicial notice of should be taken of what?
My lord,
Right, madam.
may I request with Lord's permission for my satisfaction, which is at page number 15, the learned single judge finding. It is a room for Lordship judicial interference.
Judicial interference. So there is injudicious interference also, right? So you are saying in this case judicial interference.
May I request?
Strange arguments, Mr. from government side, they today are being made. Additional AG said effective adjudication. Now you are saying judicial interference. So are we making in this thing injudicious interference also?
I'm so sorry, Lordship. My understanding is, Lordship, which is at page number 15. The law requires contract of sale.
We will. No. See, Mr. First you said one by one you explain. Judicial notice. What judicial notice?
Yes.
Of what fact? Please tell us what is judicial notice. Where it is defined. Please tell us judicial notice. You said judicial notice should be taken. What is judicial notice? And judicial notice should be taken of what? Please give two submissions, like two answers to this. So we note down. Judicial notice, under which provision it is taken?
69 might be, Lordship.
Please see, you are making a submission.
Yes, Lord.
Where, which evidence, which act?
Evidence Act, Lordship.
Section?
69.
So what is taken judicial notice? Please read. See, tell him. At least tell him whether he will listen to you.
Counsel, have you at least read the case that is Gaddam Narasimha Reddy and others versus have you read the case?
Yes, sir.
What is that about?
That is prior to Lordship and this regulation. But whereas in these facts, the transaction took place after regulation. Therefore, it has no application, Lordship.
That's been observed, already observed at page 14. Please read.
the question whether transfer made prior to the coming into force of the amending regulation 2 of 1963 and 1 of 70 are not valid either for want of registration under the Indian Registration Act or for non-compliance of the provisions of the section 47, section 15B of the Hyderabad Tenancy and Agriculture Land Act, whether the transferee would be entitled to the protection of section 53A of Transfer of Property Act can only be gone into the forum constituted for deciding such questions in respect of the land schedule areas.
That has already been decided.
That is.
And come back to page 16, findings at page 16. Your query has been answered in that view of the matter.
Yes, sir. It's true that the petitioner initially entered into agreement sale 6/1/1960. And in as much as the transfers were prohibited from the tribals to non-tribal with effect from 1/12/1963. So therefore,
Please read further.
and in the above said referred judgment, the full bench of this court has already held that the regulation have prospective in operation. The transfer in the instant case in favor of the writ petition is not hit by the provisions of the Andhra Pradesh Land Transfer Regulation Act, like amended by the 1 of 7.
So you have to argue on this issue.
Yeah, how can you, Mr. argue contrary to a law laid down by full bench? At least you have to be there to the court that yes, full bench is against me. What is this? Just like we are hearing you, therefore you can argue anything, right? So what is judicial notice first?
Lordship, just
What is judicial notice?
if there is any cloud in respect of the facts, the court has to draw the inference. If there is any facts or definition 2G is something cloud
No,
lordship.
there is no cloud. The sky is clear, no cloud.
Lordship, the 2G
Is it,
definition.
have you gone outside, saw the sky, clear or cloud? Is it raining outside? Raining?
Lordship, with my respectful submission is Lordship.
Please, Mr. Be reasonable, right? You are a law officer and you are an officer of the court. We can understand that you can request us, sir, please do not record my concession. But that doesn't mean that you will argue anything contrary to, we will impose exemplary cost on you if you argue like this, contrary to full bench, and to be deposited by you from your personal account to the Bar Association. How can you being an officer of the court, how can you argue contrary to law laid down by full bench? Go ahead. What is judicial fact? What is under which provision judicial notice? First of all, tell us. First, you have to tell us judicial notice of what can be taken and of what facts in this case has to be taken. Which judicial notice? Yes. What is judicial notice?
My respectful submission.
Submission. Judicial notice.
Section 57 of the Evidence Act.
Yes. What does it say? Yes, what does it say? Yes, madam. Evidence Act. No, he will have to pay cost if he argue. You will have to pay cost if your contentions are not rejected, right? Accepted, right? So section 57 is what? Facts of which court may take judicial notice. Yes, read section 57.
With great respect,
Please
my
read
respectful-
section 57. What judicial notice? Please read it.
the purpose of section 57 of the Evidence Act.
The court shall take.
The court shall take judicial notice of certain facts rather than exhaust the category of facts which the.
No. Something else is in your copy. We have something else, right? It reads differently.
rather than exhaust the category of facts which the court.
No.
Cases take
Section 57, the court shall take judicial notice of following facts. Number 1, all laws in the territory of India, all public acts passed by the, read it, Mr. It's your baby, please read it. You want this copy, right? At least bring the book on which you are placing reliance, right? Public notice and all that. So you should bring it to the, at least bring it. Don't depend on the court. We are not sitting here to supply you bare acts.
Out of.
Give it to him. Ah. What to do?
All laws enforced in the territory of India. Number 2, all public.
Read. Mike. Everybody should hear what you are arguing.
All laws in force in the territory of India. 2, all public acts passed or hereafter to be passed by Parliament or United Kingdom and all local and personal acts directed by the Parliament of the United Kingdom to be judicially noticed. 3, article of war for the Indian Army, Navy, Air Force.
Know this thing, right? 3, judicial notice does not arise.
Yes, Lord.
1, 2 and 3. Now 4th clause.
Successions and all.
Parliament. Read clause 4.
The course of proceeding of Parliament of the United Kingdom of the Constituent Assembly of India, of Parliament and of the legislature established under any law for the time being in force in a provision
This
of the
does not apply. Now 5th.
The accession and the sign manual of the sovereign for the time being of the United Kingdom.
So we are not dealing with any law of United Kingdom, Great Britain and Ireland in this case. Next.
All seals of which English courts take judicial notice, the seals of all courts in India.
No English law we are dealing in this case.
Yes.
Right, Mr.
Yes,
this also does not apply. 7.
7, the accession of to office names, title, functions and signature of the person filing for the time being.
Public office, we are not dealing with public office. This is not a writ of quo. So this also does not apply. Then 8.
Right, the existence, title and nation flag of
national flag we are not dealing.
Yes, Lord. The division of time, the geographical divisions of the world and public festivals, facts and holidays notified, it is not.
Is or does not apply geographical division.
The territories under domain of the government of India.
Does not apply.
The commencement, continuance and termination of hostilities between the government of India and
No
another
termination, hostility, there is nothing, right. Next.
The names of the members and officers of the court and or their deputies, subordinate officer, assistants and also.
So like no assistant officer or subordinate officer we are dealing. Next.
The role of the road and the land at sea in all these cases also.
No land and law at sea, right.
Yes.
Then what judicial notice?
If the court is called upon by any person to take a judicial notice of any fact, any fact, it may refuse to do so unless and until such person produces any such book or document as may be considered necessary to enable it to do so.
So which book you are producing to take judicial notice?
The transaction took place.
Judicial notice of the facts stated in clauses 1 to 13 you have just read. Which clause judicial notice of this thing has to be taken? Yes.
My lord.
What law? You said judicial notice may be taken. So under which clause judicial notice of what can be taken?
My lordship, with great respect, my respectful submission is the transaction.
No, you said, Mr. We are on the first issue. Judicial notice, you said judicial notice should be taken. So you have read 1 to 13. Which clause judicial notice of, and in this case of what is to be taken? These are 2 questions we are asking you.
Yes.
Please answer.
The fact,
which
lordship.
clause?
The fact, lordship. Fact.
No. You have again read Mr. Section 57. We will hear this case till 4:30. You read everything. Again 57, read.
Lordship, my respectful submission is, lordship.
Again read 57.
Lordship, my respectful submission, lordship, with great respect. The transaction took place.
No, Mr. Either you withdraw your submission or we will insist.
I will withdraw, lordship.
So there is no question of taking judicial notice. Simply you should have said sorry. Sorry, my lord, I didn't mean it. I just like saying for anything, it's not a this thing, right? We are not sitting in the park. It's a court where every sentence matters. This has led to 5 minutes of, by this time your case would have been over.
I apologize. My apology.
This intra-court appeal is filed against an order dated 18th January 2005 or 2005, passed by learned single judge, by which writ petition Next.
My lordship.
Minutes.
My lordship.
I have for the petitioner, my lords. The central government has preferred the writ appeal. It is wrongly mentioned as the private counsel. It is the writ appeal preferred by the central government.
So, you will not argue.
I'm reading just two aspects, my lords. The writ petition has been filed for initiating actions under the Land Acquisition Act, and that there is some excess land that has been taken over by the central government. My lords, there is a report that has been submitted today which shows that some extent land is present, my lords, but that report has been conducted without the presence of the central government officials. Hence, we are requesting, my lords, a week's time to ascertain whether there is an excess land that is present or not.
My lordship, I'm appearing on behalf of respondent 1 to 3, my lordship.
See the confidence with which he stood up. We knew that he is not arguing the matter and seeking. No, Mr. Forget about it. Yes, madam. What are the facts? This he is too young to this thing. Yes, madam. Please tell us what are the facts. This is for final year. This is not the way, Mr. Young person, to argue a case for final hearing, right?
Writ petition.
You have to tell the facts.
Yes.
Then what learned single judge has done, then on what grounds the appeal is preferred. Not like this thing, I want adjournment.
Yes. Writ petition has been filed, my lord, stating that the land has been acquired, but notification has been given, but the extent which has not been notified also has been taken by the defense authorities. So the writ petition has been allowed, my lord, to initiate land acquisition proceedings, my lord, where the defense has taken the land and in possession without any notification. So the present writ appeal is filed by the Union of India stating that we are not in excess of any land, only the notified and taken the land we are in possession. And when, my lord, this writ appeal has been taken, has been heard, there was a direction, my lord, to conduct an inquiry by the government officials. So survey and yes.
That's what he's seeking time, right? See, 2005. 15, 18 years, not confirmed. Where is that? And see, once it was dismissed on the ground that respondent has died. What has been filed subscription? Ah, yes, a lot. Where is the report? Report is there. Report. Report even is there. Yep. Report. Okay.
Madam, any report is filed?
You are saying the same.
They don't say, even so many savings.
So therefore the direction, Silvan.
This is the state record.
Ah, madam, report is there.
Yes.
Your report.
Yes.
What have you found out?
In the report, the second page, it has been stated that the notices has been given to the defense officials while conducting the survey, but in spite of service of notice, they have not appeared on the set date. And there is
We are not asking who has appeared. What is the survey report say?
Yes.
We will find out one.
If there is an
One.
second page last
One
part.
minute. So 1.33 guntas excess. 1.39 guntas excess land of survey number 40. Survey number 40. We clarify this. So, madam, according to the report, 1.39 acres of land of survey number 40 is in possession of the appellants, which has not been acquired.
And also another survey number, my lord, survey number 39, 11 guntas. It's in the above paragraph. They are seeking in two survey
11
numbers.
guntas of survey number.
Yes. 39, survey number 39, and the excess is of 11 guntas.
All right. So then the proceedings have to be initiated for acquisition.
Correct.
There is nothing wrong with the order.
Correct.
We will clarify. Now this has been established. We will modify the order.
My lords, may I make one submission?
Mr. First of all, before appearing for Union of India, learn how to argue a matter listed for final hearing. You did not tell us the facts. You sought adjournment. How many years of practice?
It's 8th year month.
You don't know how to argue. Huh? This is an intra-court appeal. You have to tell us what are the facts. We have gone through it ourselves and found out. And thereafter you are saying, this is not like, don't do like this. Decorum of this court has to be maintained, right?
I'm sorry.
And by us also. We can also commit contempt of the chair on which we sit, right? So we will not permit anybody else to do like this. What is this?
I'm sorry, Manoj.
You speak by here, no? From here. Speak. Nothing like.
I'm sorry, Manoj. I'm extremely sorry.
So there is a Mr. Survey report. You call Mr. Praveen Kumar. Where is he?
He's in another division bench.
Call him. This is this thing survey report by the Deputy Director Survey and Land Records, which says that you are in possession of excess area of survey number 40 measuring 1.39 guntas and survey and 11 guntas of survey number 39. So you will have to initiate an acquisition proceeding. What?
Our only difficulty is this, Manoj. We were not present during the time of survey.
Why were you not present?
Manoj, the order that was being stated was to file a report, Manoj. Since there was no direction for conducting of survey.
Have you filed an affidavit? This report has been filed on 27th February 23.
We have received it.
You have been sleeping this report for 6 months.
Manoj, we have
And
received the
at
report
the
today.
time when she is pointing out the report, we have found out you are saying that after 6 months waking up and saying that, do you want to say that this report is incorrect?
Manoj.
Despite notice, you have remained absent. All you have to do is to acquire this land. Nothing.
Manoj, our
You
only
give an acquisition, the requisition to the government, it will acquire the land for you. We are not asking handover possession. It is in your possession. You are already using, but you cannot take it in violation of Article 300A.
Manoj. Only submission, Manoj. We have received the report today. It is an admitted fact, Manoj. We have received the report today. We are only asking your Lord's indulgence to give us a week's time to ascertain, Manoj, with respect to the veracity of what has been stated in this report. We have received it today, Manoj.
Where from have you admittedly means who has admitted it?
Manoj, today, right now in the court, we have received it. Manoj.
Today you have supplied.
Yes.
So admittedly means we are not admitting it, right? You pass an order and sign it and give it to them and petitioner, admittedly. Admittedly, an order has been passed allowing the writ petition, appeal.
I'm sorry, Manoj.
This intra-court, Monday, Mr. No adjournment, we will pull you up, right? And this can't be just like seeking adjournment, right? You get it today itself. No, not only 1 week. Nothing. Tomorrow it will come up. It will not be adjourned, it will be in the list. Tomorrow you get it. There is nothing wrong to this, wrong in the report. And there is no reason why this special deputy collector will hold against you and deliberately prepare a false report. You have admitted in your counter that we are in possession of excess land. You have to only initiate the proceeding. This intra-court appeal has been filed against an order dated 29th November 2004, by which petition filed by the original petitioner has been allowed. Paragraph. The dispute between the No further adjournment.
Maybe. Well, matter where your lordship directed to, then any appeal was filed against the orders processed in LA 20 of 2000.
Delhi? What Delhi?
Well, let's, Lordship was pleased to hear this. On that ground, my late friend sought time to seek instructions. Today he filed an affidavit.
We told that he is seeking time.
Yes, my lord.
Nothing that, yes.
He filed an affidavit, paragraph 4, my lords. He admits to the fact that they have filed LR applications and PW1 was the son of the deceased original writ petitioner has given evidence as PW1. And they have filed an appeal also on 22/1/2019 by the LAASSR 1541. That was stated to have been returned on the ground. The LRs were not shown in.
So this judgment dated 26/9/2018, have you filed an appeal?
It was filed, your lordship, but
what happened to that appeal?
It was returned on certain objections stating that original court has committed a small
No, so whatever, this order dated 26/9/18 has attained finality, correct?
It was attained.
Then nothing survived.
But your lordship kindly consider one aspect against that you prepared an appeal before the Honorable Court. And appeal is pending, your lordship.
He is simultaneously saying both the things. He is saying 26/9/18 has attained finality, and then he says we have filed an appeal also.
That's correct.
Which number appeal?
No, sorry, lordship, against this order, you have
Paragraph 4 you have admitted, right? How can you, Mr. state a fact on affidavit which is he will go behind bars? If you are making incorrect submission, your client will go behind bars. So 26/9/2018, have you filed an appeal?
Appeal was filed.
What happened to that appeal?
Appeal was returned on certain objections.
What did you do then thereafter? Return for objection?
Originally, writ petition was, appellant was, respondent was erased as the R20 in the lower court, your lordship. During the pendency of the land acquisition OP, your lordship, R20 was died. We have filed a LR petition. That petition was, SR number was given and it was not ordered at the time of allowing the OP, your lordship. This order was passed against the dead person.
Which is the order by which order judgment dated 26/9/2018 has been set aside?
This matter was
set aside 26/9/2018. Which is the judgment by which the judgment has been set aside?
Not set aside.
Then end of the matter.
But your lordship kindly consider one aspect, your lordship. Today you have filed a affidavit, your lordship, and kindly told that affidavit. You have carried the matter in the appeal before the Honorable Court. That appeal is pending, your lordship. That is my respectful comment.
They say it was returned on a technical objection. What they say is, Mellors.
No, this has attained finality, right?
That's correct.
Not attained finality.
As on this date, their appeal was returned, Mellors. As on this date, that is their statement. LAS SR 1541 of
Then why are you saying he is admitting? He is not admitting it.
No, he said, Mellors, he preferred appeal and it was returned. That is my submission.
So it has been returned thereafter. What he is saying, it is pending.
He has not initiated.
It was returned, your lordship. Subsequently, you have filed an application in the lower court to bring the LRs on record. That application was allowed.
Maybe as on today, the judgment stands, Mr. No, nothing.
Today you have filed, lordship, kindly.
So it has to be set aside, right? Yes, sir. In view of the fact
reference
that
court
they
orders.
don't have the title in respect of the property, this order direction has to be set aside.
Yes.
For allotment of an alternative plot. Yes, sir.
Your lordship, kindly, before that, your lordship, kindly consider. Today I filed affidavit, your lordship. Kindly go through the fair of 5, your lordship.
No, we are asking you a simple question, Mr. Counsel, whether judgment dated 26/9/2018 has been set aside or it is still in existence? Today, as we speak at 1:30, is it still in existence or it has been set aside?
It was not set aside, Your Lordship, but appeal was carried, appeal was filed before this Honorable Court, Your Lordship. Therefore, Your Lordship may kindly see upon.
It has been, how many times will you tell that appeal was filed, it was returned with office objection? How many third time you are told? We are asking you a different question. Order date judgment dated 26/9/2018 stands. Yes. This intra-court appeal.
The order was against 10th person.
Management quotient.
Non-local, because see, why have you annexed this item number 52 order, page 52 order?
My lord, my submission, my lord, the petitioner is being treated as non-local, my lord. In the similar circumstances, my lord, this honorable court directed the petitioner to submit a representation, my lord.
Ah.
My lord, I am also seeking the same relief, my lord.
And
because
then
it's not-
say so, you are arguing on merits.
Yes, my lord, even
Ah,
my
so
lord,
that Mr. Rao will have no objection to that. Which page?
page number 53, my lord.
52 is the order, right? That's why I say so, Mr.
Yes.
This all because validity of the rule, etc., can't be challenged because you are a fence sitter, right? We have confined the relief of reading down only to the petitioners before us.
Yes, my lord.
So now you are watching the proceeding and then you have come now, so not entitled. So this page 52 disposed of certified copy today. Next.
Published, my lord.
Yes, Mr. What page?
27.
27. Yes, Mr. Rao. 27.
Yes, lord.
27. Disposed of. 27. Certified copy today. Yes, Mr. Reddy. Which page? Huh?
You want to make a representation fresh, my lord.
Liberty to make a representation. Huh? In this petition, comma, the petitioner inter alia seeks. What is the direction you are seeking for, Mr. Reddy?
A category, my lord, yes.
Seeking a direction to register the to permit the petitioner to participate in the third round of counseling. Paragraph. Petitioner is an aspirant seeking admission to MBBS stroke BDS course who had appeared in the NEET UG examination. Full stop. Statement that the fixed date was given and the matter was not listed. There is no date. You prayed for adjournment. Come here, we are speaking to you. Firstly, there is no date in your matter, and on the last date of hearing, you had sought for an adjournment and you were granted 2 weeks time to enable you to file documents.
Already I have filed the document.
No, don't, you are a judicial officer. You are a judicial officer. Don't make false statements before the court that there is a fixed date. There is no fixed date. I have myself seen in the break. Your order. Sheet. You have paid for time. It is listed after 2 weeks. There is no order. You said despite an order, the court matter has not come up. Then we told you it's a serious matter.
Today,
Mr. saying that the period of 2 weeks has expired and saying that there is a fixed date. In my date fixed by the court, these are two different things. We hope that you understand the distinction. Next. Item 3 is 4. 4. Yes.
The benefit of my order was taken into consideration, but rejection is at page 130. I made a representation seeking the benefit of my lord's common order, but however, Millards, it was rejected without taking into consideration the residence certificate which I have produced, and I have more than 10 years of residence. That was not considered.
Then you were part of that batch.
No, I was not part of that batch. So therefore, I prayed Millards, a similar relief may be given. My lords were of the opinion, you give a representation, let them consider for the third round of counseling.
Yes.
So for the third round of counseling, I made a representation.
So what has happened is, Mr. that we have taken a view. We are telling you the difficulty. We have taken a view that what we have held is that though the relief of reading down, though the order insofar as it pertains to reading down the Rule 3.3 is concerned, it is in rem. But when it comes to granting the relief, we have confounded it to the petitioners in that case. So obviously and we have written one order saying that fence sitters under Article 226 discretionary jurisdiction cannot be granted relief. So you come under the category of fence sitters who were conveniently watching the proceeding when everybody else argued before this court.
Yes, ma'am. That I support.
Or you cannot claim the benefit. First round of litigation representation considered. Now it is rejected. Now we will have to decide. You are seeking in this writ petition the benefit of the judgment passed by us on
My lords have passed the
29th August, right?
Yes, ma'am. 29/8/2023.
What is the prayer?
But I'm seeking for consideration.
1 minute, one prayer.
I'm sorry. Residence certificate to be considered, my lords.
Have the prayer.
May I read, please?
Where is the yes?
Residence certificate is at page 18. The 18th page is the residence certificate.
18.
18. 1/8. But this is to certify that so and so, my lords, I'm residing for the last 10.01 years.
That's why kindly see, my lord, that
Last 10 years, this is ex facie, this is incorrect because on your own showing, you are studying from 6th to 10th in Telangana, in that Andhra.
Yes.
Then how can,
I'll just explain.
whatever, wherever you staying for?
My lord, I stay in Nirmal, my lords. I'll just explain. Only 1 second, if you
No,
allow.
classes 1 to
6 to 10, that is the rejection. My lord, I
6 to 10 you passed outside Telangana.
Telangana. It's a neighboring state of Nirmal, that is Adilabad. So there is no education. So my father was working there. I was forced to go there.
No, where 6 to 10th, where you passed, Mr. Simple thing, state of Andhra, for whatever reason, then comes different. Maharashtra. 6 to 10th from Maharashtra. So how this 10.1 years you are residing, this is, we have to summon the Silda.
But I cannot come in your lordship's way because it is so, my lords, that people in Nirmal travel to that of Adi, the neighboring state for education purposes.
No. See, Mr. You may have some circumstances beyond your control. The problem is view taken by us and see it may be a hard case for you, right? Like this thing, it may be very good case for you, but the problem is we have to be consistent and we cannot take a different view in your case and in some other case we can. So like if you are seeking the benefit of this judgment, then sitter.
Yes, my lord. Fence sitter for second round, but I have come today itself, my lord, because your lordships would see the
Fence sitter for second round means?
Because for the first round of litigation, first round of counseling, my lord, I was not there. So I sat on the fence for the second.
Fence sitting judgment. Which judgment, Mr. Fence sitting?
I will give you. The communication of rejection, if your lordships would appreciate.
So this, no, Mr. One thing you will appreciate as an officer of the court, that this certificate is ex facie wrong. Because on your own showing, 6 to 10, you have studied in Maharashtra. And 11th and, no question of neighboring or far off Sikkim doesn't arise. The fact remains that you have not studied 6 to 10 from state of Telangana. Correct, Mr.
Yes.
And you are past 11th and 12th, let us assume from Telangana, correct?
Yes, madam.
So then how does it say 10.01 years at this address?
Because my residence.
No. So this is state of Telangana, you can't this thing. March 2020, you have passed from Maharashtra. And he's saying that for 10 years you are residing in this thing.
Residence, my lord, in
SR district, whatever, Nirmal.
Your lordships would appreciate.
No, you are a what? This is correct, incorrect, right?
I beg your pardon.
This certificate prima facie seems to be incorrect. No, we will not record your submission, Mr. We understand your predicament as an officer of the court. We want your response, right?
Yes.
This appears to be incorrect because a person cannot, this thing, prosecute study in the state of Maharashtra and stay in Telangana.
But he is not,
So he was daily going to this thing and coming back.
6 to 10. If your lordship already, even I have a food security card, which is at page 19. If that impresses this court, may I take my lords to page 9?
What?
Telangana food security card was issued to them, in which I am also there. My lords would kindly consider page.
No. What is your case then? How did you pass classes 6 to 10th from this thing, state of Maharashtra?
There's hardly any distance, my lords, for the.
No distance. What is the distance?
But the distance would be around 40 kilometers if I'm not.
40. Then is it your case that every day you went to Maharashtra and came back to Telangana?
No, my lords. My case was that my father was working there, so there I was there during that education system.
So therefore, it is apparent that you were on your own showing you were there in whatever.
For education purpose, I was shifting between the border this thing. Most of the your lordships would
So
consider.
therefore, you did not reside in Telangana for 6 to 10th.
It was 6 to 10 residents, your lordship may consider, my lords, shifting between two borders. It's very tricky for me also to admit.
I was stated in the affidavit.
Then not stated.
Lordship, kindly see the article.
Not stated. Which order?
Lordship, dispose of the article.
Yes.
Lord, the
Get the printout, mister. You don't give it to me. Get a printout and give it to us. Yes. Mister, what to do? See, mister, if you are seeking the benefit of our judgment passed on 29/8, then perhaps you are too late, number one.
For
And
third round, I'm early, my lords, because my rejection was yesterday.
no, but tell us, how can we treat you as a local candidate so long as the rule stands? It is, in your case, rule applies because it has not been read down in your case. The rule has been read down, but the benefit is in rem, is in persona. That is the petitioners before us.
Yes, sir.
So you are not petitioner in first round of litigation.
That's why-
Supposing if you would have been a petitioner in first round of litigation, things would have been different.
That's why I missed the second round of counseling, my lord. Therefore, my lords were pleased to direct me to go to the third one. Now, in the third one, this rejection has nothing. I'm faced with the rejection.
No. So, mister, now you are saying that this rule should be read down in my case also, and I should be treated as a local candidate. This is what, because I am a permanent resident. This is your case, correct? Mr. Rao. They went to Madras, most of them, Chennai. One minute. This is incorrect. Mr. GP asked Tehsildar to be cautious, otherwise see what sorts of certificates are being filed. Supposing if we take what judicial notice, somebody was arguing from your side in the morning. So supposing if we take note of that, this thing apparently a forced this thing, he won't take this thing, he won't face any problem except whatever happens to him. But your Tehsildar will lose the job, that's for sure. No, please see this order. So,
it may not be possible for
some of the petition has filed
Sixth, अच्छा बोले
That's why we passed on all this. This will apply to this para. So when were you declared initially, Mr. as
2/8/2023.
2/8/2023, correct?
Thereafter,
Non-local.
Thereafter filed writ petition.
When,
38/2023.
what was the order passed in that petition?
So consider my case.
Where page?
Page Malats, 132 Malats.
132. Thereafter, they have rejected your this thing, right? 10/9/23.
Rejection 10/9, 6:44 PM.
130.
Item number 12, P. Banu Prakash, copy from against conviction offences
All.
stated for time. Item number 13, Chase Surrender, copy from.
Yes.
This is should be issue notice to the appellant because.
May I assist, Lord, it is on 1/9. Writ petition order which my lords passed was on 1/9.
1/9.
I mentioned that, that's my apologies.
All right. 1/9/23. Mark the presence.
Item number 14.
With consent of the parties, matter is heard finally. In this writ petition, the petitioner inter alia seeks. Why should you seek a mandamus, Mr. Sarshori? You should seek no quashment of order dated 10/9/23. I don't understand what sorts of we really don't at loss to understand how reliefs are drafted here in our High Court.
Item number 15.
See, read mandamus for declaring order, not considering local candidate. All this is pro forma, right? Huh? Now you delete it from your system and start writing 1, 2, 3 so that half a page prayer can be at least understood by us. Mister, you should begin with take the initiative and delete all this mandamus. Sarshori, you must seek for quashment of order. How can this mandamus for 10/9/23? And in mandamus, we don't declare anything.
Appeal against conviction, your lordship.
See, I feel but we are putting up with whatever system is prevalent, but we should set you right by all of you by saying that this in the form of mandamus, we don't give a declaration. Everybody seeks the pro forma is like that declaration.
Against conviction or 376.
You know it very well. As a student of law, you must have read it in college when the mandamus lies. When does it lie?
When direction has to be given to authority.
See what in this writ petition, the petitioner, it's so difficult to even write that it's better to reproduce. Let anyone understand what have you written. And it's so difficult for me us to write what is it you have claimed. In this writ petition, the petitioner is an aspirant for admission to MBBS BDS course in the state of Telangana for academic session 2023-24. The petitioner has prayed for the following relief.
Against conviction, NDPS.
Paragraph. The petitioner was treated as a non-local candidate on 2/8/2019. Thereafter, he submitted a representation on 31/8/2023 for treating him as a local candidate. The petitioner thereafter filed a writ petition, namely WP number 24422/2023 on 1/9/2023, which was disposed of by this court by an order of the even date, with the direction to the university to consider the representation submitted by the petitioner. The representation submitted by the petitioner has been rejected by the university
covered only with page number 31.
31?
Page number 31.
31, Mr. Rao. Rek copy. Same order. Same order. Dismissed. Not entitled to any relief.
Page 31.
The petitioner is an aspirant for admission to MBBS stroke BDS course. The petitioner has filed this writ petition seeking the following relief. Paragraph. The petitioner was treated as non-local candidate on 2/8/2023. The petitioner, however, has filed this writ petition on 11/9/2018. Paragraph. A bench of this court wide order dated similar order is what, Mr. Rao, you know? Similar order is 29/8, he's saying.
Filed by A1 and A.
The Lordship's kind permission.
Mr. You advise your Tehsildar is issuing it. He will lose all these people will lose their jobs. They are ready to be suspended, right? Don't need salary. How much? No. They don't need any salary and all that. So they are so well off that nothing. They can survive even subsistence without subsistence allowance also, right? Yes. Okay. Next. Yes.
JK Lordship, regarding a PG medical admission, my lord, petitioner has already got the seat, my lord, in the first phase. In the respondent number 3 college, my lordship.
No, it's not covered by any order.
No, my lord, is a different matter, your lordship. Third respondent college, my lord. In the second phase, my lord, the seat has been upgraded to respondent number 4 college. My lord, third respondent is, my lord, refused to return the original certificates. Because of that, my lord, the fourth respondent college, my lord, she is unable to join the course, your lordship, my lord. Right, only I am seeking, my lord, the petition is ready to join the respondent number 4 college, your lordship, my lord.
Oh, ready, but when will you give? We will this thing grant you 15 days further time.
So lordship, but my lord, due to the, my lord, third respondent is not returning the certificates, my lord, original certificates.
We will have to issue notice, right? Then we will have to issue notice.
Because, my lord, again, this it will allot it to some other person, my lord, this petitioner will face difficulties, your lordship, my lord.
No, it will not be allotted. Where general medicine course.
Same course, your lordship.
Heard on the question of admission, learned counsel for the petitioner submits that petitioner has been allotted a seat in not return documents. This is not unfortunate. State fight, mighty state fighting against a student who is getting admission on her own merit. Does it look nice? No. Issue notice to respondents, notice on behalf of
Made prescriptions. Made prescriptions. Page number 27.
27.
Yes,
27. Certified copy today.
Hopeless.
Page number 36, similar order.
36.
Yes, Your Lordship.
36,
Consider
Mr.
representation and
36. Admitted for hearing with consent or finally disposed of. 36. We have passed an order. He has left. No, but he has gone away. You are arguing now. Call him. Mister, who is the counsel? What you not agreeing for similar order?
Because Lords may kindly see what he says is Lord.
Call him. Yes, he is arguing something, Mr. Rao, after you had left.
No.
Not agreeing for similar order.
Not similar.
20.
That is pertaining to PG course, but this is pertaining to MBBS notes. The issue and one of the same notes.
No, this is correct, right? See, Mr.
Yes,
We rely on you, right? And you do like this.
the petitioner qualified the NEET examination notes. The seat was allotted in the respond number 4.
This is a postgraduate course. How did you say similar case?
This is a issue one and the same.
No, issue in all the cases is same.
She is not reported in time, Milord.
Mister, this is, what's your name?
Sanju Jilal notes.
Write down his name.
That's my
Sanju.
My apology.
No, Sanju.
Yes.
What Sanju?
Sanju Jilal.
Write down or give it to me, better. Write down. This is unfair, Mister.
What's my
You all times we have been saying, irrespective of the result of litigation, you owe a duty to the court. What you are submitting now, you should have submitted that, sir, that order pertains to PG course, but I am seeking similar relief in undergraduate course. You said similar order and went away.
My apology.
No. See, we have caught you, therefore you are tendering an apology, which is not. And we were, Mr. Now we have learned that whatever you speak may be incorrect henceforth, so we will have to verify everything. We have committed a mistake by relying on you, right? This is what you are trying to say, that don't rely on me. Yes. What is the prayer? What is the writ petition? Argue, Mr.
The petitioner qualified the NEET examination notes. Subsequently, the seat was allotted in the respond number 4 college notes.
Yes,
the direction of the authorities notes to approach
the management quota, he was allotted a seat below
Which quota?
management quota
Management quota allotted a seat when?
in the 4th respondent college.
When?
He was supposed to report.
When?
the provisional order.
Don't speak. You spoiled your chance, right?
29/8.
Not entitled to speak.
Allotment letter date is 29/8/2023. He was supposed to report honor before 2/9/2023. He did not report. He did not report.
Now.
And he says, Lord, he wanted Lord the.
Now you are saying that your action is violative of Article 1421A. That's the case. So did not report, then now what is the prayer? The seat should be allotted to him even though petitioner sits at home. This is the prayer. Right, Mr. Rao? Grant admission. Yes. Mr. Rao. He reported at 4:15 p.m.
He says,
15.
Millard. We do not know, Millard. He says.
So is it possible for you to give admission?
Above ground counseling is there, Millard. Millard, you was allotted a seat, Millard, in a. Millard, I will take Millard 5 minutes. I just report.
Please find out.
If the seat is not filled up, Millard, let me give a direction. That's what I want to inquire.
You find out, Mr. So we will say if not already filled up.
Yes, Millard.
If not already filled up. Mark the presence with consent of the parties. Matters, right? Yes, madam.
I'm approving for petitioner doctor. Petitioner was born and brought up in Hyderabad, and he completed his studies during from 4th to 10th standard in Delhi Public School, Hyderabad.
When were you this thing treated as non-local? 2823.
Yes.
When this petition has been filed? Today. You were declared as non-local candidate, madam, on 2nd August 23, correct? The petition has been filed today, that is on 11th September 2023, that is 40 days thereafter. What did you do?
Lordship, he appears for the second council. He tried to appear and represent himself, but the respondents are denied.
That Mr. We had dictated that order. Mr. Declared same local candidate on 2/8/23, filed petition on 11/9, 40 days. Therefore, in paragraph 2 and 3, 4, that order. We will hear her. That very order has to be passed. We are telling you. Item this WP 25316. Yes, madam. So what did you do from 2nd August till 11th September? Not did we are not asking what time you got up and this thing when you had lunch. Like there is something called principle of delay and latches, right? So you are fence sitting and waiting. When you learn that these petitioners who had fought the battle have succeeded, you have filed this petition today and sought a lunch motion, right? Correct.
He tried his right for second council, but they denied. After that, we approached the council court. And on purpose of job, his father went to Haryana and there he studied for 2 years. And but the person is a local candidate also. They are not considering. He completed his studies in Hyderabad.
That's it.
This council court, several directions are given in similar cases. Many students are kindly allow this petition.
That's it. Madam, if you would have been along with those petitioners, we would have definitely granted you the. See, we understand but see, somewhere all this whole process of admission to MBBS course is a time-bound process, right? We cannot keep it open like the several hundred petition. We can see the queue waiting. They are watching your performance. The moment we say, let her be in, the petitioner be granted the relief, tomorrow 100 lunch motions will come. That we can't do because it's all time bound. So there, we have already taken a view. Thank you, madam. You have argued it well. Petition is dismissed. Next. Yes.
Like to report the Lord. Both repetitions and writ appeal Lord against the common order. Lord, where Lord London single judge was dismissed in the first repetition Lord on the ground that Lord it was already converted to non-agricultural land. Lord, there is no proceedings before the court or before the joint collector. It was converted. Lord, last occasion Lord, other side council took a time to produce any proceedings are there for conversion of non-agricultural land.
Forget about it. They are not producing, it's not there. You argue. They are not appearing also. So nobody is appearing, you be happy. Nobody is there to contest you. Oh, Mr. Rao is there. A very distinct, formidable opponent, no, Mr. Rao. Yes. Even though he smiles, yes. Be wary of him. He will make out a point. You will find it lighter when we are saying this. Yes, please.
Where Lord?
What are the facts?
Lord, the facts, Lord, the petitioner in the first matter, 92 item, where Lord he filed, he got the Padadar passbooks. Lord, the unofficial respondent, Lord, filed a revision under section 9 of the ROR Act.
Justice Yes. When is the order copy?
Lord, page 46, Lord, of the revisional order.
No. Order by learned single judge.
Page 73 to 76.
In my copy, it's page number 5 And there you are.
What is your copy, Miller? Certified copy is, the typed copy, Miller, 73 to 76.
What's my page 5, 6? Is it right? Yeah. See, until this order is challenged, the provisions of the Act will be published. Not only it can be granted. The additional stages. It would be written statistically state. See, from page 12, statements that we have. In review of should have said dismiss. Yes. Yes. Mister, you will have to argue what we know the facts. We have read it.
Petitioners below got the other passbooks below the respondent unofficial response filed a revision under section 9 of the ROR Act, bypassing the section 5B of the ROR Act below, which has to file appeal. Below, on that period, it is a scheduled publication below, revision section 9 also maintainable for against the order of the MRO and RDO before the collector. Below, on that point, I am not there. Below, the contention before your lordship is before enjoying the property, before using the property, an agricultural land must be converted into non-agricultural property. There is a procedure under section 3 of now Telangana Agricultural Land Conversion for Non-Agricultural Purpose Act 2006.
Ah, yes. It was, see, Mr. The learned single judge has mainly held that by an order dated 15/5/2006.
Yes, sir.
This, it was held by the joint collector. The revision was allowed by the joint collector on the ground that this, once the land ceased to be an agricultural land, this act does not apply.
That's what I'm saying, Milord. My contention before lordship is, understand the single judge, another single judge also, Milord, if suppose it was seen to be agriculture, there must be notification. Or there is application by the concerned party with the documents before the RTO. Milord, under section 3 of the act. But there is no proceedings, there is no gazette publication by the state government as suo motu. Now, only on the ground that my joint collector come to the conclusion, there is all
What order the land was converted from agriculture to non-agriculture use?
Yes, sir.
Which order?
Milord, there is no order. They have to produce, Milord. On the basis of that, Milord, he was converted. They said that it was Dabadi. Section 3 of the Act, Milord. Submit.
Where is the order dated 15/5/2006?
Yes, sir.
Page
46 to 62.
40?
6 to 62.
15/5. Yes. What does it say? All right, we'll 1 minute. So where is your sale deed? Sale deed.
Passbooks.
Sale deed. Sale deed.
Milord, I am the ancestor property, Milord. I have to passbooks.
No. You had purchased the land through registered sale deed.
No, Milord. They claiming.
Petitioner before revisional petitioner had
Yes, yes.
Ah.
They unofficial respondent.
unofficial. Is there this thing sale deed on record?
No.
All right. Yes. See here. See this. 156. Hmm. 56. Same, yes. Purchase 56. Yes. See, huh? So you are a party to sale deed dated 26/7/2004.
Normally.
The respondent has sold away the land measuring one.
This is a
Page 56, come to 56. Respondent is, what is your name?
look the survey number 380.
Respondent is Gantu, yes, Gattu. Petitioners are, appellants are Gattu. You are respondent in the revision petition.
Revision petition.
So page 56C, what has been written? C.
C, my lord.
Respondent has sold away. Means you have sold away the land 1.31. Read it, mister. Read it.
The respondent has sold away the land for the extent of 1 acre 31 guntas. 31.5 guntas to the petitioner on 26/7/2004 through registered sale deed. Document number 6007/2004. The respondent is now questioning the locus of the petitioner and submitting that she is no way concerned with the land survey number 385.
So therefore we asked you, you are a party to the sale deed dated 1 minute. Mr. Please understand, we have to decide. So therefore you should listen to the queries of the court, right? So 26/7/2004, you are a party to the sale deed, correct?
But my instructions.
Because you have sold the land to petitioner.
Lord, my instructions, my lord, the extent is more, below 585, 385, 386, 23
We
acres.
have understood what are your submissions. Number one, there is no order of directing conversion of land.
Yes.
What else?
Lord, in survey number 385 and 386, my lord, 23 acres is there, my lord. Out of 23 acres, my lord, through 3 shares are there, my lord, and 5 acre 39 guntas were come to the petitioners. Lord, I have to ascertain, my lord, whether in.
We don't know. You don't ascertain. You argue, please. We asked you. You don't know. Said it is not on record. So first thing your submission is that there is no order of conversion of this land into non-agricultural land.
And another,
number one. Number two, second submission.
My lord, as per the my lord, joint collector's orders, my lord, what she says, my lord, already Pura was granted layout. Where my lord, our property was not there. It was not involved in the property, in their land. Because extent of 23 acres, my lord, they have only purchased the property of 1 acre 31 guntas. In 385 and 386. Another thing, my lord, they are shown as per the even joint collector's order, my lord, in 385 and 386, 5 acre 39 guntas was shown as a grandfather of the petitioners. And thereafter some period was it was not reflected and DRO was issued a letter of proceedings. According to the proceedings, MR was issued a particular passbooks after conducting inquiry. But the contention before the joint collector is no notice was put on the respondents. Because while issuing a notice in ROR Act, they must be reflecting the revenue records.
Yes.
Nobody knows whether they are purchased the property or not. 1 acre.
Yes.
That to 1 acre, my lord.
Yes.
And another thing, my lord, the mere conversion of the land, mere granting a Kuda layout, whether they have to purchase the land first, my lord, they have to show the documents up to 5 acre 39 guntas, which are claiming by the both writ petitioners. Even according to them also, 1 acre 31 guntas were they purchased property.
So without going to that Millard, and other thing, Millard, before coming to the conclusion, by satisfying the Padadar passbooks, they are not followed. If suppose there is no notice was issued by the MRO, it has to be remanded back and conducted for further inquiry. But simply the order of the joint collector is not set aside for other passbooks. Lordship, kindly see Millard the direction of the joint collector at page 62, Millard.
All right, anything else? That's all. Yes, Mr. Rao. That excludes non-agricultural land. So what is the material? No, that's why your first submission is that there is no order converting the land for non-agriculture. This is what the first submission. Okay. All right. Yes, Mr. Anything else?
There is no title dispute, but they are claiming to the petitioners only, family only. 1 acre 31 guntas. Millard, 1 acre 31 guntas they are claiming, Millard. Millard, total land is 23 acres, Millard, even according to the joint collector's order. The Lordship kindly see, Millard, in the order it reflects.
No, the proceeding pertain to only whatever is purchased by them, not your land, right? He's saying no, they are not claiming title in respect of the land not covered by sale deed.
No, joint collector says, Millard, entire land was converted and the entire land was put in the Kuda level. That is what the joint collector says. And the
if you want that clarification, we will say that this proceeding on only in relation to the land purchased by him through a sale deed from you. If that is the grievance.
1 acre 31 guntas. Obliged.
You are happy with that?
But if they are claiming that, Millard, on the entire.
Mr. No, correct. But you are concerned with your land covered under your sale deed.
Obliged. But for filing a suit, Millard, they are claiming 1 acre 31 guntas. Millard, 5 acre 39 guntas, the Padadar passbooks are cancelled.
Be clarified by saying that it pertains to 1.31 acre. Only to that extent, whether that this land is covered in this layout, we should be excluded. 1.31 acres, right?
Yes.
We will clarify that.
Yes. Obliged. Because they are cancelled the 5 acre 39 guntas 2 passbooks. That is the impute before your lordship.
Mr. Rao, you are concerned with your land only. Whatever that. No, we are maintaining the orders passed by the authorities. We are only clarifying that this order pertains to land purchased by you, which is measures 1.31 acre, right? White sale deed executed in the year 2006. Right? Yes. So 93, 94 are same, right?
Yes.
Same order.
Same order.
No, this is not a common order, different order, right?
You know, the same, under the same, Agnesha, same common order, my lord, we find that it.
This is not, but this is not a common order. It's order passed in WP 22381, mister.
Look, what happened, my lord, earlier this writ petition was filed against the same order of the joint collector. That was learner single judge was dismissed the order, writ petition. In a judgment, we carried a writ appeal. My lord, the present writ appeal against the learner single judge order. My lord, thereafter, my lord, another writ petition filed by some other respondents in the same order. In the revision, my lord. It was tagged to the writ appeal. Same common order before the
You
judge.
are not appearing in that rate petition. Rate petition.
Writ petition.
So we will dispose it off in view of the order passed in WA, correct? That rate petition. Correct?
Writ petition, my lord,
This intra-court appeal arises out of an order dated of only Saley. Once you fight it out, we don't.
Liberty may be granted for the.
No liberty.
Your Lordship says, my lord, your Lordship is restricted to that order. Set aside in the Padadar passbooks.
So in respect of remaining land, you are at liberty. Needless to state that in respect of remaining land, the petitioner shall be at liberty to take recourse to such remedy as may be available to him in law.
Obliged.
Yes. Yes, you can take the- Yes.
I'm appearing for the respond number 7. Respond number 9 to 15, my lord.
No.
The item number.
Appellant. Who appears for appellant?
Item number 96. In item number 96, I'm for the appellant.
Yes.
Placing for adjournment, my lord.
No adjournment.
But senior counsel is there, my lord, till
No,
1:30.
you are senior counsel. We have designated you. Notification will get you couple of days. Wednesday. With effect from today for this case, you are designated by division bench as senior counsel. Go ahead. I'll forget, Mr. No.
Once he was there, my lord.
No.
1:30 minutes he was. He went for
No.
my lord.
So therefore,
Attend for a funeral, my lord.
3:50 you are here. 1:30 he was there and 3:50 you are here.
He went to attend for.
Nothing. Please do not waste our energy. Yes. 95. We will decide it. If you want to go away, you can go. See, we have taken out to do justice. We will pass an order to the best of our capacity without your assistance. 90, 95 and 96 are connected matters, right?
Yes,
What is the order?
The judgment of the Honorable Supreme Court, which your lordship may kindly consider, page 13, your lordship may kindly consider. Para 8, para 7 and 8.
Mr. Rao, which case you are appearing?
Both cases, your lordship, I am for the writ petitioner and I am made as a respondent here.
No, not respondent. We are for the appellant. We are. We will hear you.
Much obliged.
Yes. See, brother. Nothing. Yes. Correct, Mr. Rao. Nothing wrong with the order. Yes. You are for respondent, right?
I am for the respondent.
Nothing. We find that nothing wrong with the order passed by Learned Singleton.
Your lordship.
All right. Okay.
Much
Yes, Mr. Anything else?
Request for tomorrow, my lord.
No, nothing tomorrow.
That is item number 95 is.
All right. Mark the presence, arguments heard, reserved for delivery of judgment. Both the cases.
Much obliged. Much obliged.
Mr. Madam, these two files, lordship. Yes. See, we designated you senior advocate. Despite that, you did not open your mouth and you are smiling. Fine. Nothing. You can't do anything, Mister. What can you do? You told, you did your duty. We did what we wanted to do. We have done our duty. Fine. Thank you. Come ready, Mister. Not everything, because don't just stand up for saying adjournment, because court may not adjourn like this has happened. Mr. Rao has, by his, what can you do? You told, we did your duty. We did what we wanted to do. We have done our duty. Fine. Thank you. Yes. But the appeals are dismissed, Mister. Right? The come ready will follow. Not everything, because don't just stand up for saying adjournment, because court may not adjourn like this has happened.
Please, your lordship.
Mr. Rao has nothing, no senior. What can you do? Designated your duty. We did what we wanted to do. We have done our duty. Number 2. Fine. Thank you. Yes. But the appeals are dismissed, Mr. Right?
No,
9
obviously
will
you
follow. Not everything, you just don't just stand up for saying adjournment. Now no
Because
adjournment.
court may not adjourn like this has happened. Please go ahead.
Mr.
No,
Rao,
nothing.
if you have any idea,
What can you do?
we did what you guided us.
We did what we wanted to do. We have done our duty.
Fine. His case could also have been taken up tomorrow,
But
right?
the appeals are
When we have
dismissed,
not
Mr.
granted
Right?
for the
9
will follow.
will
Then don't be under an impression that
What
we
we
will be
wanted
sitting
to do. We have done our duty.
Fine.
Thank you.
For us, everybody is same.
But the appeals are dismissed, Mr. Right?
For the
9 will follow.
Not everything is fine, otherwise, don't, please sit down. We will look into it.
So they put me landing violation of 14.4. 14.5, therefore, notice for resumption was given. And that challenge then this has been dismissed. Resumption. Nothing wrong. She's appearing, she's asking for a pathology, so you have no examination.
Yes, madam. What do you say? Correct. So this notice was issued as they had violated 14.5 of the Act. 14.4 and 5. So therefore, one case show cause notice, other 4 cases order of resumption. Nothing wrong.
Madam, the extent of transfer, how it is possible to Sir, to transfer 26.28 cents acres,
My lord, your lordships are referring to which page?
page 13. Under provisions of Sealing Act, once thereafter if you are assigning.
Yes.
There will be some limit to.
My lord, this is the extent of 12 acres, 7 guntas has been assigned.
Each 12 acres.
No, all together, my lord. Your lordships would get the parcels of land, my lord, in the counter affidavit filed by me, my lord, at page 50, your lordships.
No, I am referring to the order, page 13.
Yes, your lordship.
It says that to an extent of 26.28 cents, 26 acres, 28 cents. How can that vast extent of land can be assigned?
Lord, this is but the allotment of land was to the extent of 12 acres, 7 guntas.
Illegally allotted.
My lord, the extent of land is only 12 acres, 7 guntas, which was assigned, my lord, to 5 members. That particulars, your lordship would get it at page 49 of the counter, my lord, filed by me.
Okay.
All right.
This was adopted 2.17 and 2.
Anything else, madam?
My lord, senior counsel lost the
Fine.
attended a budget
No.
meeting, Lord, and due to
Nothing. Fine. Nothing. What's your name? Reserved for judgment. Yes. No. Not. Send these 3 files to all that. Yes. Yes. What is it?
Item 98, my lord, I appear for the appellants, my lord. I beg to represent Mr. Ashwini Kumar.
Yes. Yes. What is it?
Yes, my lord, sir, writ appeal, my lord, arising.
Of course.
The appellants before your lordships are.
What is the point?
Yes, correct.
Like in previous case, we found out that notice issued under as they violated condition under 14.4 and 14.5 and order of presumption. So what is the point involved in these cases? Writ appeal, anybody can make out. First is writ appeal, second is writ petition up to 108. What is the point involved?
Yes.
Don't know.
My lord, this is about 6,000 acres of land which was assigned, my lord, which was acquired by the state and kept aside for assignment. My lord. This Jawahar
This
Nagar.
is same, right?
Yes.
Jawahar Nagar.
Yes.
Madam,
Yes, madam.
you are sitting quietly. That's why we were confused.
Jawahar Nagar.
Jawahar Nagar. Yes, you have taken us this thing. You have taken back that whatever you said that you will prepare it afresh. Please give it. You are the lead counsel in these petitions.
Sorry.
Everybody has adopted your submissions. Your case is that instead of 15 lakhs, land should be granted to me.
Only 2 points I would like to put across to your
A
lordship.
rejoinder you can submit. No?
My lord,
A rejoinder you can submit.
only 2 points only.
She was addressing us,
Very well.
you remember?
Very well.
Then by rejoinder we will hear you, not 4, 5, make 5 points.
Very
Why 4 only? Make 5 points.
Those people are wrong. We said our case is different and not to be seen. 1 lakhs. 15 lakhs instead of 15 lakhs.
Yes, madam.
My lord, I have circulated to 3 copies, my lord. One is relating to the brief note on about Jawahar Nagar, my lord. How the land after the British troops was taken in custody by the state and
Note on Kulwant Singh. Chetwal. No. Note on Jawahar Nagar.
yes, my lord.
First one.
First one.
Yes.
Then,
Yes.
my lord, here is a note, my lord, which explains the 5,977 acres of land, my lord, was a wasteland and it was in the custody of the British Army initially. After the World War II, my lord, after demobilization of the Second World War, the Jawans were entitled to some parcels of land, my lord,